being conducted via Zoom. Present is Attorney Maria Zagorski. Ms. Zagorski, you're representing the plaintiff mother, not the maternal grandmother. Is that correct?
I represent Sarah Olson, who is the guardian of the mother.
Thank you. So the record, Ms. Zagorski is present representing the plaintiff's mother's guardian, Sarah Olson. Ms. Olson appears to be present with Ms. Zagorski. Thank you for that clarification. In addition, defendant Attorney Corey Shimmick is present.
Chantel Neff on behalf of Corey Shimmick.
It's Attorney Neff. Chantel Neff is appearing on behalf of Attorney Corey Shimmick, representing the defendant father, Michael Lavanos. Mr. Lavanos is present. Good morning, everyone.
Good morning.
Good morning.
Parties have conferred with front of the court this morning, who has recommended the father of sole legal and sole custody of the minor children. The father agrees not to move the children from the state of Michigan without prior approval of the court. I believe that was concern previously stated when the plaintiff initially filed the motion. I'm sorry, when the defendant originally filed the motion for sole legal custody, was that not to give the defendant father the opportunity to simply move from state of Michigan without the consent of the mother, and hopefully that mother will improve in her medical condition. Is Miss Chanel Olson still residing in a nursing home?
She is, Judge.
Okay. Have the children visited her? I believe that was, the court previously allowed that at the discretion of the children's counselor.
Judge, the court granted me the opportunity to conduct discovery, and I did try to depose the children's therapist to find out whether that was a good idea and what she recommended, but defendant father wouldn't sign a release, and so the therapist really couldn't provide me any information.
So the children have not seen their mother then? Is that correct?
That's correct.
All right. Right, Ms. Zagorski, is this recommendation agreeable with your client this morning?
Unfortunately, Judge, I don't think I have a choice under the law, and so the answer is yes.
Okay. Right. Ms. Neff, is this recommendation agreeable with your client this morning?
It is.
Okay. Is Ms. Chanel, is her condition improving where she can speak with the children?
It is not, Judge, unfortunately. My client is going to have another neurologist do a workup because she moved during her last scan, and so they didn't get a good read about her neurological activity, and so we don't really have any news to report.
All right, thank you for the update, Ms. Zagorski. Anything further than this morning, Ms. Zagorski or Ms. Neff?
Yes, Your Honor. There were just two things. I requested the name of the court reporter that opposing counsel used for the deposition, so we can request a transcript. Opposing counsel does not want to provide that to me. I would like to be able to order a transcript from that.
Did your office not appear at the deposition?
We did not.
There's no notice provided?
I believe Mr. Shimmick informed them that he was not going to attend.
Okay. Ms. Zagorski, any objection to provide the name of the reporter who conducted the recording of the deposition?
Yes, Judge. My client paid for that. They would certainly be entitled if I used that in an evidentiary hearing or if it were an exhibit. But at this point, my client owns it. As I indicated, defendant father didn't cooperate, didn't show up. He did have notice. He wouldn't sign a release. And so quite frankly, I'm not feeling very cooperative. My client did have to pay for that already. And so I don't feel that she should have to provide anything to him.
All right. Ms. Neff, what was the other issue?
The other issue is that my client had to pay $1,500 to the therapist for the deposition. And we would request that the opposing party pay that bill.
I'm sorry. First of all, Ms. Mayor is not before the court this morning. I think you should file a motion and brief it. I mean, why would Mr. Levinas pay $1,500 for deposition but not have his attorney appear at the deposition? What am I missing?
The therapist is charging my client for it.
And was the therapist subpoenaed for the deposition?
I believe so.
Well, at this time, the court's going to adopt the recommendation of the front of the court this morning as to granting the defendant father sole legal physical custody of the minor children with the understanding that he shall not move for the children from the state of Michigan without prior approval of this court. Any other issues that need to be brought before the court by a proper petition and a brief? The court will not address those issues at this time. Ms. Neff, perhaps Mr. Shimmick, or you can talk further with Mr. Zagorski. If you can't reach agreement, you can file a motion with the court and brief the issue.
Thank you, Your Honor.
All right, that will conclude this hearing. Now we can zoom out the rest of the day. For the court to review defendant mother's parenting time, this hearing is being conducted via Zoom. Present is Attorney Eugene Ferguson, representing the plaintiff father, Cody DeFalco. Mr. DeFalco appears to be present with Mr. Ferguson. In addition, Attorney Christopher Fleming is present, representing the defendant mother, Lauren DeMille, and Mr. DeMille appears to be present with Mr. Fleming. Good morning, everyone.
Morning.
Good morning, Judge.
Good morning, Your Honor.
The last order of this court entered in October, provided for supervised parenting time for defendant mother with family counseling child services. The parties have conferred with Mr. Walker from the front of the court this morning. Mr. Walker is recommending that mother have specific unsupervised parenting time as follows. Every other Saturday from 10 a.m. to 3 p.m. The mother shall provide proof that she's attending AA meetings to father or his counsel every 30 days. Neither party shall consume alcohol or any non-prescription drugs immediately before or during parenting time. And anyone that transports a minor child must have a valid driver's license. Finally, the parties will appear back for court to review mother's parenting time on February 5, 2025 at 10 a.m. via Zoom. That is the recommendation. Mr. Ferguson, is this recommendation good with your client this morning?
No, we object to the recommendation.
Okay. I'll talk to Mr. Fleming. Mr. Fleming, is this recommendation good with your client?
My client would accept it at this time, Judge.
All right, Mr. Ferguson, the basis for your objection, I guess, first of all, the question the court has mother been regular exercising your supervised parenting time with family counseling shelter services?
She has, Judge. She's attended, I believe, approximately 7 sessions at this time. There has been reports from that generated. I believe I sent them over yesterday to your secretary, Judge.
Not seen them. Not seen
Okay.
Mr. Fleming.
All right. But in essence, Judge, and Mr. Ferguson agreed that all of the sessions have been going well. There have been no issues whatsoever with the sessions, and they've been going excellent.
All right. And Mr. Ferguson, presumably Mr. Walker makes the recommendation having reviewed all the reports from the supervisor at Family Counseling Shelter Services. So what is your client's objection to unsupervised for, it's like, what, 4 hours, 5 hours on alternate Saturdays?
My objection is this. From the beginning of this case, the defendant had supervised parenting time. She's never had unsupervised. We filed 2 motions because of her very poor behavior. The first time we filed it because she was vaping marijuana around the minor child in the presence of her supervisor. This time we filed it because on August 31st, 2024, he had the minor child in a car seat. She was driving without a license, without a supervisor. That's why we filed this. Because of that, the court said that she would have the supervised parenting time we talked about earlier. And somehow, because she did 7 very supervised parenting time, now she gets unsupervised. She's being rewarded, in a sense, for violating the court orders not once, but twice. I also don't see that somehow she understands that she's wrong about this. Opposing counsel in front of the court indicated that the problem is that my client overreacted, that he traumatized the child when she's driving without a license, without a child seat, and somehow she's going to be rewarded, and now she's going to have unsupervised parenting time. I don't think she should have something better than what she had prior to this, because she's violated court orders not once but twice in a very egregious manner. And I think that if we want to go back to the parenting time we had before, that's fine. I would prefer that my client be the supervisor because her mother has been a poor supervisor on 2 occasions. The court can continue what we have now for a while, but I know eventually we're going to be doing something else. I would rather that whatever parenting time there is, that my client be the supervisor.
Mr. Ferguson, if you're going to put words in my mouth, make sure they're at least accurate. What I said in front of the referee, Your Honor, was that Ms. DeMille absolutely accepts the wrongs that brought her here back in October 2nd. She knows she shouldn't be driving without a license. She accepted that. But also the fact that the plaintiff did traumatize a child on that date. According to the video that I saw, the child was crying when the plaintiff father stopped her. But regardless, she has accepted her wrongs. She knows what she did was wrong, and she's willing to abide by all court orders 100% going forward. Every day she tells me that she cries because of the situation she finds herself in, that she put herself in, and she knows that she put herself in, Judge. She accepts that, and she has done what is required to go forward, and she's been doing excellent, Judge. She has been in AA since January and has been sober since that from alcohol, Judge. I know that the plaintiff keeps on and loves to harp on that she was arrested all these times. And the last time she was in trouble for the alcohol offenses was in August of 23. But we certainly accept the alcohol provision, Judge. And I think it is in the child's best interest to start seeing his mom unsupervised. It's unnecessary at this point. We certainly accept that they're wrong, that she realizes that she can't drive even, 2 blocks down the road. She accepts that that was wrong and knows that it's in the child's best interest that she doesn't do that, Judge. But at this point, it's in the child's best interest for Ms. DeMille to have unsupervised parenting time with her child for 5 hours every other Saturday.
Well, Mr. Fleming, the credibility of your client is certainly is brought into question. It's like, well, I can do what I want, but as long as I don't get caught. So obviously, the court questions her credibility and says, "Oh, I'm not going to do this again." The judge gets caught. With whom does Miss DeMille currently reside?
She does stay with her mom, Judge, and it wasn't a matter of not getting caught or anything like that. She just had a new child. When was your child born?
August 17th.
August 17th, Judge, and the mom was staying home with the new child. She promised the child here, Everett, ice cream, and she wanted to get the child ice cream. She knows that's absolutely wrong. She doesn't do it just to flaunt the court's orders by any stretch of the imagination, Judge. But of course, it's up to your honor, but I think she was just trying to make the child happy, and she realized that she was wrong.
Well, again, it's obviously not an emergency. Mom can go to the store and get ice cream and bring it back to the house rather than put the child in that situation. Is Miss DeMille still on probation?
Yes, she is
Sorry.
on probation still through Lucas County.
And when does that probationary term expire?
But technically, I don't think for 3 years. So, but okay.
2 years from when, Mr. Fleming?
6. So it should be 2006 or 7. Okay. When did it start?
I believe
23, 24, 25, 26.
It would be
Either 26 or-
2026, August of 2026, Judge.
Or actually, hold on. It didn't get put. No, it'd probably be the following because the accident happened in August, but because of me being hospitalized and whatever, it didn't actually happen set until February.
So probably February 2027.
Yeah, probably around then.
February 2027, Judge.
I had to think about it. I'm sorry, Your Honor.
And how often does Miss DeMille attend A meetings? How many times per week?
Weekly, at least 3.
Has Miss DeMille exercised all the parenting time to which she was entitled to with Family County Shelter Services, or did she miss any sessions?
She has exercised all sessions, Judge.
All right. Who will be transporting, if the court adopts this recommendation, who will be transporting the minor child to the defendant mother's home? Is it the maternal grandmother?
Yes, Judge. Mr. Mills, wow.
Okay. Is Ms. DeMille required to submit to regular drug screens as part of her probation?
Breathalyzers at random or anything at their discretion, I believe.
Okay. Court talking about drug screens. Did she just use marijuana? Is that prohibited under terms of probation? Does she submit to random drug screens?
No.
Okay. What about the holidays? Is the front of the court holiday schedule been adopted in this case? Is there any discussion about the upcoming Christmas holiday?
There was not any discussion, Judge, but that is an excellent point. I mean, I'm sure Everett would love to see his mom on Christmas.
Yeah, I would love to see them.
Birthday.
Christmas, of course, this year is on a Thursday, but that was not raised during your discussions this morning. Obviously, the court would encourage it so that the child can spend some time over the Christmas holiday. The child's what, 6 years old? As far as the child's concerned, Christmas lasts a whole week. In any event, the court's going to give a mother another opportunity to prove herself, and the court will adopt this recommendation. It's limited, 5 hours every other Saturday, no overnights. And the mother must provide proof that she's attending A meetings. Why can't that be provided weekly rather than every 30 days? Recommendation says she'll provide it every 30 days. So if the court adopts the language of this, Mr. Ferguson will not receive a proof of A meetings until early January. So presumably Ms. DeMille is getting a verification sheet completed every time she goes to a meeting, correct, Mr. Fleming?
That's correct, Judge.
Okay, any reason why she can't email that or fax it to Mr. Ferguson or Mr. DeFalco weekly?
I see no issue with that.
I should be able to.
Okay, so she can provide, do it on Friday or Saturday. I'm not sure what day she attends. So the court can adopt a recommendation with one, the modification. Mr. Walker, if you can modify this, the mother should provide proof every 7 days. So weekly. So the court suggests she provide that proof Friday or Saturday morning. Friday, the day before, the weekend, the Saturdays, alternating Saturdays that the court is awarding, so that Mr. Falco has documentation that mom is attending 3A meetings that preceding week.
Thank you.
So I don't know if we need to be more specific that mother should provide this weekly prior to mother's just weekly. The intent of the court is that it be provided on the Friday or Saturday preceding mom's alternate weekend parenting time. So Mr. Walker, if you want to word that, I think of course made it clear how that's been. We just put that to be done. It should be provided weekly. And that should be sufficient with the court's clarification that the court would hope that Mr. Falco would receive that on the Friday prior to mother's alternating Saturday parenting time. And if there's any issues, Ms. DeMille, you need to, if there's any issues, you're going to go back to supervised parenting time at that agency. So it's you need to strictly comply and adhere to this.
Yes, Your Honor.
All right. Is there anything further than this morning, Mr. Ferguson or Mr. Fleming?
I have nothing else.
No,
Okay.
Judge.
All right. All right. That will conclude this matter. Thank you, Mr. Walker. The court will adopt the revised recommendation. Copy will be sent out to council. See everyone in February then.
Thank you.
Thank you,
Questions
Judge.
about?
Thank you.
Have a good rest of the
I
day.
met with the parties
Okay.
on the 9:30. They are both on public assistance on the same case at DHS. And typically we would not have a child support order if they are residing together on the same case.
Hey, it just bothers me. It seems like why should taxpayers support their children? But I have no authority in that regard.
I can run child support, but with them living in the same house on the same case at DHS, they're both on public assistance.
So I guess they need to put in their before the judge just reserve the child support. Is that what we should do? Because it does not address it.
Yeah, it could be reserved. What would happen is if one of the parents leaves the home with the children, say if dad was out of the home, DHS would send a referral to our office to do a child support recommendation anyway. So we would have a child support order once they separate.
But it just rubs the court the wrong way. They can live together until the children are 18 and the taxpayers are going to support those children.
Understood.
Any other suggestions?
I don't, unfortunately.
Okay. But that's your understanding is that the court cannot order that when they're both under the same case until they separate?
I believe the court, has the authority to do anything. I can run the child support, but with them living in the household, it's
Right.
they're reimbursing their own public assistance.
They can reimburse the state of Michigan rather than go to one parent. Maybe run that by Stephanie, see if she has any if that's possible, just to reimburse the state of Michigan.
She stepped out of the office.
Okay.
I did speak with Mr. McKee. His position is to reserve child support until they live separately. I believe it is their intent to separate at some point
Okay.
when they're
How do we
financially
know-
able to do so.
Okay, yeah, that's what I'll do. But how do we know when they separate? if they'd never notified the front of the court?
When they separate, they'll notify DHS,
What if they
and
don't? What if they
DHS
don't
will
notify
send a
anyone?
referral. Every 6 months, they have to renew their case at
Gotcha.
DHS. And so
Gotcha.
they'll be
Okay.
notified that one of the parents is out of the household.
Okay, yep, thanks for that
Okay.
explanation. Okay.
I'll
Thank
bring
you.
them
just
out.
reserve it then. Thank
Okay.
you. Okay.
On the matter, Whitney Betts versus John Betts.
For the record, this matter is before the court on the plaintiff's motion to enter a consent judgment of divorce. This hearing is being conducted via Zoom. Are you Whitney Betts?
Yes.
And sir, you are John Betts?
Yes.
Okay, good morning. Both parties are present and this actually seated next to each other, which is wonderful. You've talked with front of the court regarding child support, and you're both on the same public assistance grant. So the court will reserve child support at this time. However, there's an issue of filing fee. You both appear to be young. I'm not sure if you're disabled, unable to work, but there is a filing fee that was previously waived, and the court wants to address that in its judgment of divorce. And I'll give you as much time to pay that. It's a $255 filing fee. And the court wants one of you to pay that, the other person can reimburse it, and I'll give you as much time as you need to pay that $255 to the Monroe County Clerk. So do either of you have any employment income?
Yes, we both are employed.
You're both employed?
Yes.
I'm sorry. I didn't hear you very well, Ms. Betts. Can you speak up a little bit?
Yes, we're both employed.
Okay. Yeah, it's sort of an echo, but in any event, in the judgment divorce, I'm going to put one of you needs to pay it. The other person, you're both living together, correct? You tend to live together. So do we want to put in there that Whitney will pay it or John will pay it?
Which one? Me.
Oh, okay.
I will.
John, that's $255. How much time do you need in which to pay that?
Can it be cash or credit card?
You got to, maybe you need to speak closer to your device. We're not picking you up very, very clearly.
Okay. Do you guys take any forms of payment?
No, it's got to be one lump sum. They will not take installment payments. They'll take a credit card, but they're going to charge you a fee for using a credit card over the phone, or you can come in with cash and pay it. You'll save yourself a few dollars by paying in cash rather than a credit card. They will not take personal checks. They will not take installment payments.
3 months.
Okay. Okay. It's 3 months, so you can pay that by the last day of February is February 28th.
Yes, Your Honor.
Okay. And if you can't pay, you need to contact the court and ask for additional time, because when you blow it off, that's when bench warrants issue for your arrest. We don't want that to happen.
Understand.
Now, again, obviously, Ms. Betts can help you with that. She can give you some money. Why does it take 3 months for the court to monitor this for 3 months? Can you do it at the end of January?
I was thinking more of holidays, and then 3 of the kids' birthdays are in December.
Okay. Okay. But did that give you you're both employed and you receive public assistance? Even though there's Christmas and birthdays, you can't do that by January 31st, 2 months?
Yeah.
Okay.
Yeah, I can do 2 months. That's fine.
So January 31st is the last day of January. If you need more time, call the court, but I want you to make good faith effort to pay that $255. I'm going to write in this judgment, they should pay $255 on or before January 31st, 2025. Mr. Bestis, contact the court if in fact you can't pay the full amount by then, but put some money aside, or if you got a credit card, you can pay it over the phone on the credit card. That'll give you more time to pay the credit card. You just need to give the county clerk, because you both know where that's located, second floor of the courthouse. Okay. The other matter the court needs to address is, since there are minor children, there's a statutory 6-month waiting period to make sure there's no chance of reconciliation. The 6 months begins running the date you file this petition for divorce. That was filed on October 3rd. The 6 months expires April 3rd. But this court does have the authority to waive that and end the judgment of divorce today if you both agree, you both believe it would be the best interest of the children to finalize things sooner than later. Finalizing, getting the divorce today rather than April 3rd. Ms. Betts, you asking the court to waive the statutory waiting period and enter the judgment of divorce today rather than wait until April?
Yes, please.
I believe that would be the best of your children to finalize things sooner than later.
Yes.
Same question to you, Mr. Betts. You asking the court to waive the statutory 6-month waiting period and enter the judgment of divorce today?
Yes, Your Honor.
Do you believe that to be in the best of your children?
Yes, Your Honor.
Right, the court will do so. Can you both raise your right hand to be sworn, please? Thank you. All right, we'll hear from you first, Miss Whitney. Can you please state your name and current mailing address for the record?
Whitney Nicole Betts.
Thank you. Is it true, Miss Betts, you filed a petition for divorce on October 3rd, 2024?
Yes.
Is it further true that on the date you filed that petition, you've been a resident of the County of Monroe at least 10 days and the state of Michigan at least 6 months?
Yes.
Is it further true that there's been a breakdown of your marriage relationship with John Betts to the extent that the objects of matrimony have been destroyed, there's no chance of reconciliation?
Yes.
Is it true that there was 2 children born of the marriage who are still minors, Jonathan and Vivian?
Yes.
Were there any other children born or adopted during your marriage who are still minors?
That are still minors? No.
Are you currently pregnant?
No.
And you signed your name to this consent judgment approving the terms and conditions contained therein, is that correct?
Yes.
All right. Mr. Betts, can you please state your name and address for the record?
John Dwayne Betts.
Thank you. That was much better. Mr. Betts, did you hear the testimony this morning of your wife, Whitney?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes, Your Honor.
And you also signed your name to this proposed judgment approving the terms and conditions contained therein, is that correct?
Yes, Your Honor.
Okay, the court's going to go through this with both of you. You both agreed that you will share joint legal as well as joint physical custody of your 2 minor children, which is wonderful. The court applauds you for that. Parenting time, once you separate, shall be by agreement. If the disagreement arises, you can always petition the court for a specific parenting time schedule. But hopefully you can work that through together. Be on the same page for the benefit of your children. With respect to child support, the court will reserve the child support. I'm going to write the word reserved. I'll put my initials next to that. So if you do separate, the front of the court will petition for a child support order to enter so that the state of Michigan can be reimbursed for the state of Michigan for the public assistance being provided. Spousal support, known as alimony, that you've agreed that's not awarded and it's forever barred.
Yes.
You attach to your judgment a personal property and debt addendum, which will, and your debts are divided according to that debt addendum. Namely, the plaintiff Whitney is awarded $250 in a savings account at the Monroe County Community Credit Union, as well as $250 in a checking account at the credit union. Defendant John is awarded the same. So you're basically going to close out those 2 accounts. Each of you will get half. Is that correct?
Yes.
It's probably better to separate things so we don't have problems in the future. So any joint accounts, separate these, withdraw them, put them in a new account in your own name. There's credit card debt. So the plaintiff Whitney shall pay, looks like you're splitting it down the middle. Whitney shall pay an Amazon credit card in the amount of $500. John will pay an Amazon credit card in the amount of $500 as well. So it's approximate. In addition, there's a credit card to the Monroe County Community Credit Union. Each of you will pay $1,000. Whitney will pay $1,000 to the credit union credit card. John will pay $2,000 to a care credit. The Lowe's card has been paid off, correct?
Yes, we're working on that.
So it shows Lowe's is zeroed out. That takes care of all the debt. If you have any debt in your own name, when you'll pay that, and your debt in John's own name, he'll pay that. These are the joint debts, the Amazon, the credit union, and Care Credit. With respect to real estate, the two of you own the real estate and own that property is awarded to both of you. You both agreed that that home will be ultimately sold and you'll share equally the net sale proceeds. Is that correct?
Yes.
When do you plan on putting that in the market in the spring?
Probably in the next few months, we're hoping.
Okay. So two of you own that.
Yes.
Finally, with respect to, there's also an income tax addendum that the plaintiff, Nicole Whitney, is awarded the right to claim the two children as a dependent for tax purposes for 2024 and all future tax years.
Yes, yes.
With respect to personal property in the home, once you separate, can you agree to divide that, pots and pans and things of that nature?
Yes.
Yes.
Okay. Vehicles, you each keep your own vehicle and pay any debt associated therewith. Again, the real property is awarded to, according to the attached real property addendum, whether it's going to be liquidated and split equally. Each will be entitled to their own retirement plans, whether it's an IRA, 401k, or pension. And Miss Betts, Miss Winnie, you're going to keep the name Betts, correct? You're not asking for a change of name?
Yes.
I'm sorry?
Yes.
All right, thank
Yes,
you.
maybe.
All right, Miss Winnie, do you have any questions for the court?
No.
John, do you have any questions for the court?
No, Your Honor.
Well, and Mr. Best, just make a note in your calendar to pay at $255 on or before January 31st to the Monroe County Clerk. And based upon the testimony that's been provided this morning, as well as complaint filed in this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. The court will sign the judgment. A copy mailed out to both of you. That will conclude this hearing. Good luck to both of you. Have a good holiday with the kids. It's one thing you can co-parent your children. They will do well if you're both on the same page. I applaud you for that. In the event that will conclude this hearing, you can both zoom out and have a good rest of the day.
Oh, thank you so much.
Have a wonderful day.
Thank you.
Calling the matter of Rashane Yates versus Christopher Young.
For the record, this matter is before the court on the defendant father's objection to a referee recommended order denying his motion modified child support. This hearing is being conducted via Zoom. Ma'am, you are Jane Yates, is that correct? I'm sorry?
Yes, sir.
Thank you. And Christopher Young, you're president of audio, is that correct?
Yes, sir, that's correct.
All right, good morning. Two of you have conferred with Mr. Walker from the front of the court. Mr. Walker has recommended the court that the referee recommended order be rescinded and canceled and that a new child support order entered in the total amount of $448 per month. That would be effective back to October 1st, 2024. Mr. Young, do you understand the recommendation? Mr. Young, are you still there?
Yes, sir, I'm still here. I understand, sir. I'm here.
Okay, yeah, and you're agreeable with this recommendation, is that correct?
Yes, sir, that's correct, Judge.
All right. Ms. Yates, do you understand the recommendation?
Yes, sir.
Yeah, do you have any objection to the court adopting this recommendation?
Not at this time.
All right, thank you, Mr. Walker, for reviewing these financial issues with the parties. The court will adopt the recommendation, so the Mr. Young, your child support is modified. It's reduced down to 448, but that's going back to October 1st, 2024.
Your Honor, just so that you know, I sent you the uniform child support order that I also sent you on base. Has the wrong effective date on it, so I'm going to send you a new one with the October 1st, 2024 date.
Okay, thank you. All right, so Mr. Young and Ms. Yates, that concludes the matter. You both have a copy of these orders. Now we'll conclude this hearing. You can both zoom out. Have a good rest of the day and holiday.
Thank
You too, sir.
Thank you. For the record, Ms. Ingalls Prossi is appearing via Zoom from the Monroe County Jail. Also present is Monroe County Attorney Rebecca Hicks. Ms. Hicks, can you provide the court some information about Ms. Prosty Engel's obligation to pay child support.
Certainly, Your Honor. In this case, there is a current support obligation of $242 per month. The current balance is $6,582.08. It looks like the last payment was received in August of 2023.
I don't know if you got my voicemail on Friday or not, but I did call on Friday, Rebecca, to you. I don't know. I never heard nothing, and then that happened yesterday.
Yeah, I did receive a voicemail. The courts were closed on Thursday and Friday due to the Thanksgiving holiday. And by the time I tried to return your call, it appeared as if you might have already
here
in custody.
Yes.
I will note for the court, Your Honor, and I'm not sure if she's been arraigned on it yet, but it looks like there is a criminal matter also holding Ms. Engel in the jail. Have you been arraigned by another judge yet this morning?
No, this is the first judge I've been in front of. I've only seen the attorney.
It'll be 2 o'clock this afternoon.
Thank you. Your Honor, that charge does appear to be a felony embezzlement charge according to AS 400. So the friend of the court would not want to waste any jail time regarding ours while she's going to have that to be contending with. This is a Judge Lohmeyer case. What I would propose is that we have no bond on the friend of the court's case and do a short adjournment back over to Judge Lohmeyer's docket so I can monitor what is happening regarding her felony criminal matter.
All right, Ms. Engel Prosty, are you currently employed?
Yes, I am.
By whom?
Yangping on Dixie Highway.
How long have you been so employed?
This week will be a month.
Have you been paid yet?
Yes, I've not had a full week there yet. I know that much.
Okay. Well, if you've been working for a month, you've been paid. Why didn't you pay any of that toward your child support?
That's part of the reason why I also called Rebecca Hicks. I've only worked like 1 or 2 days a week since I've been there because they've been flexing us out.
Okay. And you've not made a payment in over a year. So have you been unemployed for the past year?
I mean, my kids have received money from me, but I've not made, you're right, I've not made money on child support through the front of the court.
Well, you're a candidate for jail time in this court's opinion, but it's a Judge Lohmeyer case, so I'll have Judge Lohmeyer decide that. I mean, you're young, able-bodied. There's no reason why there's a lot of employers in Southeast Michigan that are screwing for employees that get your job today. But then,
my doctor also had me, I'm sorry. I also have, I also had turned in a note to I think it was one of the referees at one point in time last year that my doctor did take me off work for a long period of time. And I also had one from back in June stating that I was still off of work. And when I finally came back here from Florida, I have to work. I have to, like, no matter what's wrong with me, I have to. There's no ifs and buts. So, I mean, if I can present that letter, that's fine.
Writing a note to someone in front of the court does not reduce your support. You need to file a motion to reduce your support if you're unemployed or you're on disability, Ms. Engel Prosty. But in any event, Ms. Hicks, you're recommending just a PR bond for personal bond for Ms. Engel Prosty and giving her a date for Judge Lohmeyer?
Yes, Your Honor, on January 8th at 1 p.m.
Judge Lohmeyer available sometime this month?
I could get her in on December 18th at 1 p.m.
The court prefer that.
Okay.
Then
December
later.
18th at 1 p.m.
Right, so Ms. Prosty, the court's going to authorize release on this front of the court bench warrant. No bonds required. Well, let me ask you, who do you live with?
I live with a friend. I left an abusive relationship, so I'm currently staying with a friend.
Okay. Do you have any savings accounts, bank accounts?
No.
All right, with the court to follow Ms. Hicks' recommendation, you're certainly a candidate for jail time in this court's opinion, but we'll let Judge Lohmeyer decide that. You're to appear for Judge Lohmeyer December 18th at 1 p.m.
Okay, thank you.
December 18th, that's 2 weeks from tomorrow, 1 p.m. A copy of an order will be sent over to the jail. One will also be mailed to the address you've referenced.
Okay.
And so you can appear by Zoom to meet with Ms. Hicks on December 18th at 1 p.m. That information will all be sent forth in the order. Copy of the order will be provided to you when you leave the county jail if you're able to postpone the criminal charge. Do you have any questions?
No, sir.
Court would strongly recommend that you reach out to family and friends and be prepared to make a payment on or before December 18th. Hopefully get your job back. Anything further, Ms. Hicks?
Nothing further on this matter, Your Honor.
All right, and unless you have other questions, Ms. Engel, you can step out.
All right, thank you.
Welcome. Okay.
Calling the matter, Amy Ostrander versus Kevin Kilgore.
For the record, Mr. Kilgore is appearing via Zoom from the Monroe County Jail. Also present is Monroe County Front Attorney Rebecca Hicks. Okay, that Rygate address seems to be what the front of the court has on its records. Mr. Kilgore, are you being held in jail on any other charges?
No.
Okay, for the court bench warrant, Ms. Hicks, can you provide the court some information about Mr. Kilgore and his support obligation?
Certainly, Your Honor. In this matter, it is an arrears-only case. The current balance is $4,098.03. We last received a lump sum payment on August 29th of this year of $475.33. There is no previous finding of contempt in this matter. And it looks like we did just suspend Mr. Kilgore's license last month as a result of this case.
All right, Mr. Kilgore, obviously you were mailed a notice to appear. You didn't appear for that review, and that's why the bench warrant issued. You need to pay attention to things. And you need to get your license straightened out. Right now, your license is suspended.
Yeah, can I talk real quick?
Well, you can talk with the Ms. Hicks and to see what needed to get your license restored. But the question the court has for you, are you currently employed?
Yes, sir.
With whom?
Tommy Davison's and son.
Tommy Davison?
Yes, sir.
What kind of business?
I drive roll-off trucks, CDLA.
So well, you can't drive, obviously, if your license is suspended.
Yes, sir.
So does that employer have other work for you?
I got money to bond out. I think we got the 1,900. I thought I did my taxes. I was supposed to get 6,000 back. I got a form in the mail from Treasury saying it went to child support. I was under the impression that my child support was paid off. While I'm here to do a change of address. I just moved last month to Flat Rock. I'm not positive of the address. I've been there, so I just moved. I don't got the address. I got a townhouse for me and my son. Probably why I didn't get the note of the thing in the mail. But I mean, if I knew I still owed money on the child support, I'd have been paying. I was making payments on it as soon as I got my license back. But like I said, I mean, I got 6,000 back on my taxes. And I got a letter from Treasury saying it went to Monroe County for child support. So I was on.
You said that. You already said that, Mr. Kilgore. Okay, you made a payment. You made a payment in August of this year at $443. You were not aware of that payment?
No, I mean I was making payments, but then I thought it was paid off. Like I said,
where did the payment come from? Income withholding order?
No, Your Honor. The payment came from what Mr. Kilgore just stated on the record.
Well, I don't know what
we
led you to believe
received one
paid
payment.
off.
Your Honor, I can't talk about people's tax information on the record.
Okay.
We received a lump sum payment of $475.33 on August 29th of 2024. We've received a lump sum payment of $3,091 in January of 2024, but there is still a balance of $4,098.03 left on his case.
Okay. Do you have any questions, Mr. Kilgore, Ms. Hicks?
No, not at the moment. I just want to say I apologize.
Ms. Hicks, do you have any questions, Mr. Kilgore?
No, I do not, Your Honor.
Okay. What's your recommendation this morning?
Your Honor, that we move forward with a finding of contempt. He's able-bodied and employed and not paying. He just went under an assumption that stuff was paid off without verifying it for himself. We sent him a notice prior to even suspending his license, letting him know we were going to move forward with that. We do that so that they can't reach out and contact us because he had a bench warrant. Then when that 21-day objection period goes by, a hearing is set with the referee and notice is mailed out with that. Then the referee makes a recommendation to suspend a license with a 21-day notice getting mailed out. And when no objection is received to that, that's when we suspend licenses. This bench warrant has been on lien since April 29th of 2024 after Mr. Kilgore failed to appear at a hearing in April of 2024, Your Honor.
Thank you. Mr. Kilgore, you're being charged this morning with civil contempt of court for failure to pay child support. Upon conviction, you could be ordered to serve up to 45 days in jail. Since there's a distinct possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all that?
Yes, sir.
All right. Do you own any property of any value?
No.
Automobile, bank accounts?
No. I lost it all when I was here last year.
Do you own the home in which you reside, or do you rent?
I just started renting.
Okay. When were you last paid from Tommy Davison?
2 weeks ago.
How much do you have left of that?
I was under the impression that I had a 1,900 cash bond, and I got people working on that. I should be able to make the 1,900 if that's still available.
Okay. Any objection to 1,900 cash bond, Ms. Hicks?
No, Your Honor.
Would that be able to reinstate my license by chance?
No.
We'll talk about that later this week. So, Mr. Kilgore, the court's going to grant your request for court-appointed attorney. Why don't you give me a cell number in case you postpone? The attorney can reach you on your cell phone.
That'd be great. It would be 734.
Okay. All right. The court's going to schedule us for hearing. on Thursday, December 5, 7:15 a.m. Mr. Kilgore, you and the court will require you post a bond of $1,900. If you post that, it'll apply toward your arrearages. It's going to reduce your arrearages. It'll benefit you.
Absolutely perfect.
And if so, you can appear via Zoom. If you post that bond, get back to work. And when you got a judge, come over and talk to Ms. Hicks and see what you need to do to get lifting this license suspension. If the only issue before this court is how much time you're serving jail. Hopefully you can post that bond, come over as soon as you post that bond, and tomorrow talk to Ms. Hicks about what you can do to get your license straightened out.
All right, I appreciate it, Judge. Just can you guys also keep please put a note in? I am a full-time dad to a 9-year-old also that I got full custody of.
Well, you should take care of your business, Mr. Kilgore. Shame on you for not being there. You got to take care of your business and avoid these bench warrants.
I'm trying, Judge.
Do you have any questions, sir?
No, sir.
Okay, the hearing will be on Thursday of this week. We need to get a couple days, some time, adequate time in which to appoint an attorney. Attorney will reach you by phone. If you're in jail, they'll communicate with you over at the county jail. And it's Thursday, December 5, 11:15 a.m.
I appreciate it.
Okay, make those. Hopefully, post that bond.
All right, sir. You have a good day.
Thank you.
I do not, Your Honor.
Yeah, in Ingalls, and there's the embezzlement charge she was sent from her grandmother. Took all her jewelry and emptied out accounts. I mean, that's horrible.
Yeah,
So
I don't
she
get the
gotta-
details of it, but I saw it was embezzlement between $1,000 and $20,000, I believe is the charge. So I don't anticipate her being released from the jail before we come back in 2 weeks in front of Judge Lohmeyer, but we'll review it at that time.
She's either, and plus she's gainfully employed for a month at Young Fish. She either had a drug or alcohol problem. And that's just horrible to be still from your grandmother. In any event, I just wanted to make sure you're aware of that.
Yes, thank you. I appreciate that.
Right. Good morning, Mr. Ruddy.
Good morning, Judge.
Right, Daniel Slaughterback present on audio.
Yes, I am. Hello.
Good morning. And this hearing is being conducted via Zoom. Present also is Attorney Thomas Ruddy, appointed to represent Mr. Slaughterback. Also present is Monroe County Attorney Rebecca Hicks. The court would note that Mr. Slaughterback did post a $1,000 bond over the weekend and was released. And did not appear on Monday. Thought the hearing was on today, but he did appear today, so that will negate the issuance of another bench warrant. Mr. Slaughterback, I'm glad you called yesterday. Mr. Ruddy, have you had a chance to discuss this matter before with Mr. Slaughterback?
Yes, Judge.
You've also had a chance to talk with Ms. Hicks as well, is that correct?
Yes.
And what does he wish and desire, Mr. Slaughterback, this morning?
Mr. Slaughterback is going to admit to the contempt.
Okay, and if the court accepts his admission to contempt, Ms. Hicks, you recommend that the court simply suspend any sentence and continue this matter for review, is that correct?
That is correct, Your Honor. As he had indicated, he is employed. I see in our system that we sent income withholding notices, so we would request that he inquire with his employer if they received it. If not, he also should have received copies in the mail that he could take in to them as well, but he needs to make payment until it starts being withheld from his paycheck.
Thank you. Do you understand that, Mr. Slaughterback?
Yes, I do.
Look at your pay stub. If not coming out of there, you need to make payments directly to the front of the court. All right, so Mr. Slaughterback, are you satisfied you have received your right to legal counsel by conferring with Attorney Thomas Ruddy?
Yes.
Is it correct that you wish to admit to contempt this morning?
Yes.
Do you understand the court would impose a suspended sentence of 45 days? But the court's going to give you the key to the jail. Namely, you would not spend 1 day in jail unless you fail to comply with orders of this court. Understand that?
Yes.
All right, Mr. Slaughterback, raise your right hand to be sworn, please. Do you solemnly swear affirm that the testimony you're about to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, Mr. Slaughterback, please state your name and current address for the record, please.
Daniel Reed Slaughterback, December.
Mr. Slaughterback, do you admit and acknowledge that you're obligated to pay child support for the maintenance of children born to you and Caitlin Heyer?
Yes.
You admit and acknowledge that you have outstanding arrearages in the amount of approximately $14,000.
Yes.
You further admit and acknowledge that you did not, the last payment you made was in September of 2024 in the amount of $200.
Yep, that was the one time I showed up to court to pay, yes.
Okay. Have you had any income since September 2024 when you made that last payment?
Yes.
And you admit and acknowledge you've not paid any child support from that other income from that date?
Nope, never paid anything else besides the $200 cash.
Thank you. Mr. Ruddy, do you have any questions of Mr. Slaughterback?
No, Judge.
Do you have any questions, Mr. Slaughterback?
Nope, everything's covered.
Ms. Hicks, do you have any questions, Mr. Slaughterback?
No, I do not. Thank you.
All right, the court finds that Mr. Slaughterback has a support obligation. He's ignored that obligation. His lack of due diligence is the basis for contempt. He has significant arrearages, approximately $14,000, has not made any payments since September 2024, notwithstanding the fact that he's had income since that date. Accordingly, the court will find Mr. Slaughterback to be held in contempt of court for failure to pay child support. And the court will intends to impose a suspended sentence. Mr. Ruddy, is there anything you want to say on behalf of Mr. Slaughterback before the court does so?
No, Your Honor.
All right, Mr. Slaughterback, anything you want to say?
Nope, all good.
All right, the court will order that you serve 45 days in jail. However, reserve that sentencing, hold it in abeyance, or you to continue making support payments. I'm going to give you a date to come back before review. Mr. Ruddy can be relieved at this time. Thank you, Mr. Ruddy, for your assistance. Ms. Six, what date do you suggest for Mr. Slaughterback to appear before you for another review?
28 at 8 a.m.
28, 8 a.m. Okay.
January?
January 28 at 8 a.m.
Thank you.
Okay,
Mr. Slaughterback, you already appeared for
calendar.
Ms. Six on January 28th, 2025 at 8 a.m.
Okay.
So, again, if you fail to appear that date, bench will issue, and again, you can control your access to the jail. You can avoid any jail by simply paying attention to this obligation. If you break your leg next week, file a motion to reduce your support. Be proactive. Do not ignore this obligation. And you need to, the court will, in fact, I think the court ordered yesterday that $1,000 bond you posted, shall be released to apply towards your arrearages. So you got arrearages about $13,000. You need to get that below 10,000 because otherwise the Attorney General is going to pay attention to this case and charge you with a felony charge of non-support. So take care of this.
Sorry.
Try to pay more than your current support, Mr. Slaughterback, to reduce these arrearages. Okay.
Yeah, that was my plan. That's what the guy I was talking to told me. It helped me out a lot.
And if you have a reduced income, file a motion to reduce your support. Just don't sit on your hands.
Okay. Yeah, I need to do that because I was making 1,000 or more, and I'm not making that anymore.
Okay. Anything further than this morning, Ms. Hicks?
Nothing further, Your Honor.
All right. Any questions, Mr. Slaughterback?
Nope, everything's covered. Thank you.
Okay, you're welcome. That will conclude this hearing. Thank you again, Mr. Ruddy. Everyone can zoom out. Have a good rest of the day.
Thank you, Judge.
Thank you, Your Honor. I'll finish getting those orders uploaded to your queue.
Alrighty. Am I good to go?
You're free
So
to
good
go.
You
Mr.
can zoom
Slaughterback.
out. Good luck, sir.
Okay, I hope you guys have a good day.
Thank you as well. For the record, this matter is before the court on the plaintiff mother's motion to establish child support. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff mother petitioner, Heather Harmon. Ms. Harmon is present with Ms. Zagorski. And sir, you are Donald Martell, is that correct?
That's right.
All right, the parties have conferred with Ms. Barr from the front of the court, who has recommended the court enter the following order: that commencing November 1st, 2024, that Mr. Martell pay child support in about $644 per month. It's a $617 base support, $27 ordinary medical for a total of $644. The plaintiff mother paying 29%, defendant father paying 71% of any uninsured medical expenses. And that post-majority support is adopted through June of 2025. The court recognizes the child has attained the age of 18, but will not graduate till June of 2025. Is that correct, Ms. Gorski?
It is, Judge.
Right. Ms. Gorski, is this recommendation good with your client?
It is. Thank you.
Right. Mr. Harmon, do you understand the recommend? I'm sorry, Mr. Martell, do you understand the recommendation?
I understand.
Do you have any objection to the court adopting this?
I don't know that I can pay that consistently, Your Honor.
Well, this is based upon your current income, or your recent income, year-to-date income. Do you expect a layoff?
Your Honor, I haven't worked for Ford Motor Company since 2018.
How do you support yourself?
I live with other people.
Well, they can help you pay your child support.
They can't.
are
They're
you
not going to give me
disabled?
money.
Are you disabled?
I'm type 1 insulin dependent diabetic with neuropathy.
Okay, the front of the court has a 4-page list. They update it monthly of employers in Southeastern Michigan that are screaming for employees. There must be some job that you can accommodate. If you're disabled, you need to file for Social Security.
Yes, Your Honor.
So the court's going to adopt this recommendation. You need to, there's holidays. There's a lot of employers looking for employees. There's something you can do. Come down to the front of the court today and get a copy of that 4-page list. It's updated every month. Good paying jobs. No reason why you should not be supporting your child, Mr. Martell. So the court's going to adopt this recommendation 644. Don't get behind. This is effective November 1st. So you already owe November and December about $1,200. So you need to make a payment forthwith. Anything further in this morning, Ms. Skorsky?
No, I'll prepare a uniform child support order and submit it under the 7-day rule, Judge.
Okay. Any questions, Mr. Martell?
What if I can't pay it?
Well, if you can't pay it and you're not looking for a job, there's a possibility you can be held in contempt of court and go to jail. Hopefully you don't put yourself in that position. I'm telling you right now, in front of the court is a 4-page list of employers that are screaming for employees.
Right, Your Honor.
You get a job today. Something
Your Honor.
And if you're disabled, you can't work because you're neuropathy, then file an application for Social Security. You can't just sit home.
Okay, Your Honor. Ford Motor Company is one of the highest paying hourly jobs in the entire country. If I can't find a job to match that sort of wage, how do I pay that?
Well, first, I mean, right now you say you have friends supporting you. This is part of your support. If your friends are supporting you, they can help you pay this child support. It's based upon your past income. I don't know if you get that job back for Ford Motor Company. I don't know what the situation is.
That's something I could ask them to do, but it's possible they may say no. And you're telling me that I would go to jail.
If you don't pay, if you're not making a good faith effort, that's correct. So the pleadings indicate that you're doing construction work and you recently sold your home in Monroe and received a significant sum of money from the sale of your home.
I did sell my home, Your Honor.
Okay. So hopefully you've saved some of that money. You can pay this child support.
Okay.
Does that answer your question?
Yeah, I got it.
Okay. You might need to sell some other assets to pay this child support. But anyway, the court's going to adopt the recommendation. It's based upon your past income. And do you receive any disability from Ford Motor Company?
No, I don't.
Okay. So maybe contact the lawyer if you have some claim against Ford Motor Company. In any event, you need to support your child, so the court's going to adopt this recommendation. We mailed a copy. Now conclude this hearing. You can zoom out.
Thank you, Judge.
Thank you, Ms. Brower. For the record, this matter is before the court in the defense motion to address or to establish an order of custody and parenting time. This hearing is being conducted via Zoom. Present is, ma'am, are you Samantha Sharer?
Share, yep.
Good morning. Also present this morning is Attorney Leslie Carr representing the defendant, Father James Heeden, I'm sorry. Hedin?
Yes, sir.
Hedin and Mr. Hedin is also present. Good morning, everyone.
Good morning, Your Honor.
The parties have conferred this morning with Ms. Patrick, who's provided the court the following recommendation: that the parties shall share joint legal custody as well as joint physical custody of the 1-year-old minor child with the primary physical residence with the plaintiff mother. The defendant father shall have parenting time every other weekend from Thursday until Sunday, as well as every other weekend from Thursday until Saturday at 10 a.m. The parties shall share holidays. If they cannot agree, then the fallback will be the front of the court holiday schedule. In addition to dad's parenting time, shall have 2 Zoom contacts per week. Mother will have Zoom contact when the minor is with the defendant father. Parties shall use app close to communicate regarding the minor child. That is a recommendation. Ms. Carr, is this recommendation agreeable with Mr. Hedin?
That recommendation is, there was one other issue that we did address with a friend of the court. That's regarding the tax exemption of the minor child. We were asking to alternate years, starting with the odd years for Mr. Hedin Ms. Shire was not willing to do that, and so the friend of the court did not make a recommendation on that matter, but we are still requesting that moving forward.
Right. Otherwise, the parenting time schedule is acceptable.
Yes.
When will that start? This week?
Yes.
Yes.
So will this week be Thursday until Sunday or Thursday to Saturday?
Thursday through Sunday.
Okay, just want to make sure everyone's on the same page. Hopefully they can work through the Christmas holiday schedule. If they can't, the friend of the court holiday schedule will apply. Ms. Shar, what's your objection to the two of you alternating claiming the minor child's dependent for tax purposes?
I honestly, last year when he filed for taxes, we barely had talked about who was claiming our son on their taxes, and he just kind of did it.
Well, it's best that the court address that in their order so there's no wondering who's got it. What's your objection to moving forward? Ms. Carr suggesting that you claim the child on even years, which would be 2024. And Mr. Dean would claim the child on odd years.
No, I feel like that I should be able to claim him every year for taxes.
But you agree with this parenting time schedule, is that correct?
Yeah.
Yes. Well, 1 week he's got the child 3 nights overnight. Another week he's got 2 nights overnight. It's a reasonable request. Ms. Patrick, do you have any recommendation in terms of parties alternating the tax exemption?
Yeah, the friend of the court usually will not do that because the parties were not married. And I don't know what the child support amount is going to be. So the court is correct. Dad's going to have 10 overnights a month, which is not quite half. It's close to half, but it is not. And mom did not agree to it. So when the parties are not married and the parties cannot agree to it, we usually do not make recommendations on tax exemptions.
Thank you. That makes sense. So what are we going to do about child support? Was there any discussion about child support?
Yes, Your Honor. There is also a PA order that is going to go through. Ms. Carr's motion was filed almost simultaneously with the PA's case, and so they kind of ran into each other. So in that case, the order was to recommend for the child support, and the parties have already received the paperwork under that order that came out of the PA's. So I did not mention it in this recommendation because I don't want 2 recs going at the same time.
Should we not try to address everything this morning? Or is it better just let it take its natural course?
Well, if we let the rec go, because they've already got the paperwork they're going to fill out and turn it in, then they'll have 21 days to object to it. But I can also put it in this rec too. I'm just afraid they're going to get double paperwork if I put it in this rec. Okay.
All right. Well, yeah, Ms. Carly, at this point in time, the court's going to reserve that issue. If in fact there's and obviously the special prosecutor does not make a recommendation. They just simply make a recommendation on child support, correct? They're not going to make a recommendation on claiming child as a dependent for tax purposes.
That's correct, Your Honor.
Well, the court hates to see the two of you have an argument because we're close to the end of the 2024. So who had the child most in this 2024 calendar year?
I did, Your Honor.
We lived together, Your Honor, until August. And then from August on, I have had him for most of the time.
Who has a greater income?
I do, Your Honor.
He does.
Well, Mr. Hadeen would benefit more by claiming the child, and perhaps the two should work out maybe with his assistant, Ms. Carr, in terms of some arrangement where if Dad could claim the child, Dad would reimburse Mom a certain amount of what he gained from claiming the child.
He was supposed to do that last year, Your Honor, and he did not. I was supposed to get a little something out of what he got from claiming our son on his taxes, and I didn't.
The reason that didn't happen is when she was laid off due to being pregnant. We went through a long period of time to where she wasn't having any income, as well as I was going through the UAW strike. So a lot of my
she was
work
carrying your
would be-
child, Mr. Dean. She was carrying your child.
Yes, I know that, Your Honor. I was trying to catch up on everything we were falling behind on. That is what I used the taxes towards.
And when I started
there
going
was a
back
discussion
over,
and there was a talk of it. The only time an issue came up is when she filed her taxes and noticed a little bit that she received. At that point, that's when there was an issue about me filing for Henry. And everything I used was to keep us up and moving, to keep rent paid and keep electric on. You know, I know she was down and she wasn't working, and I was being hurt myself too around the time.
You
I was
spent
just trying
a
to make
lot
sure
of
that she
money
moved
on
forward.
things that didn't need to be spent on.
All right, so the court doesn't want the two of you to both claim the child because then you're going to create more problems. So the court's going to grant plaintiff mother the right to claim the child's benefit for 2020, 24 only. Future years will be reserved. So at least you going into filing tax returns in January or late January. Let's not create more of a problem by both you claim the child. So this order, we're going to add this order that the plaintiff mother is entitled to claim the minor child's benefit for tax purposes for the 2024 tax calendar year.
No problem.
Years, the two of you talk about it. And if we need to, the court will decide that in the future. There is some merit in alternating future years. But we'll reserve that to a later date. Of course, not going to rule on that, but only with 2024. So if you can add that provision, Ms. Patrick, to this recommendation, the court will adopt that. Anything
Yes,
further
Your
this
Honor.
morning, Mrs. Carr?
No, thank you, Your Honor.
Anything further, Ms. Shar?
Nope, as long as I get to at least claim them on taxes.
Well, for the 1 year, for the current year.
Yep.
To work together. I mean, there's a lot of things you can do. Be creative. A lot of times you want to get the best bang for the buck. So if dad claims child features, maybe put the extra money that he received, put in a bank account for the child.
Well, that's what was my original plan, is if I would have claimed Henry, our son, last year, is I would have made a bank account for our son. And honestly, I got the idea of that from our friend that does the same thing with her child support money. She puts it all into the account for their daughter. And I would like to do the same thing for our son. That's why the taxes, I know they would go into an account. The account would not be touched.
I have also started
Okay, maybe if you did that this year, that would show Mr. Dean that maybe you should do that in future years if you allow him to claim the exemption, because he'll probably get more of a return. So the court suggests be open-minded and discuss that in the future. In any event,
I started
on 2024. The rest is reserved. Mr. Dean, you can talk with Ms. Carr how to address that in the future. Okay, that will conclude this matter. You can all zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
You're welcome. Could you remove your hat, please? You're in court.
Yeah, I apologize.
For the record, this matter is before the court on the plaintiff's complaint for custody. This hearing is being conducted via Zoom. Present is Attorney Chris Fleming, representing the plaintiff, Isabel Grand. Mr. Grand is present with Mr. Fleming. And sir, you are Tyler Stockard, is that correct?
Yes, Your Honor.
Of course, this court didn't enter an ex parte order on November 21st, 2024, which awarded exclusive possession of the minor child of the parties to the plaintiff mother. Reserving the issues of child support, child care, medical care. That order also required the parties to appear today for this review. So both parties have appeared. The child is 2.5 years old. Mr. Stocker, the court's informed that you wish to adjourn this matter so you can retain an attorney. Is that correct?
Yes, I already have an attorney.
Okay.
He's just not present. He's just not present right now. He's at a doctor's appointment.
The court sees that no attorney is not present. Who is the attorney?
Seymour Schwartz.
Okay. He's not filed an appearance. He could always file an appearance even though he's not appearing today. But in any event, the recommendation this morning from Mr. President, this matter be adjourned to January 7th at 2:30 so that Mr. Stocker can have counsel present. Mr. Stocker, do you understand that will delay the time that you can have parenting time?
Sadly, I do, Your Honor.
Right, Mr. Fleming, any objection?
No objection, Judge. We did try to schedule mediation, but that was kiboshed. I don't know if the judge wishes to order, but I know December 16th at 1:30 with Aaron Brower is available.
Perhaps you can reach out to Attorney Schwartz and see if he's available for that date to pen in to at least secure that date. But the court will not order that at this point in time.
How long do I have to do that, Your Honor? Because I'm gonna get on the phone call with him after he gets out of his doctor's appointment.
I'm sorry, what is your question?
Am I able to still, if he advises me to do that, am I able to call into the courthouse or show face and
Yes.
request the mediation? Okay.
Most mediations are Zoom, but obviously if Mr. Schwartz doesn't reach out to Mr. Fleming, that mediation date may be gone by in a week or so. So you may want to tie down that date if Mr. Schwartz sends a copy of his appearance to Mr. Fleming, and then Mr. Fleming knows he's on board. Then they can perhaps schedule that for mediation on that date that's available. But otherwise, if we adjourn this to January, the ex parte order will continue. Do you understand that?
Yes, Your Honor.
It's unfortunate Mr. Schwartz could not appear today. This is obviously something, and the reason why the court set up for review is because the court does not want to delay the time that you're not able to have contact with your child, Mr. Stockard.
I understand that. He was supposed to be in, but he hasn't been feeling very well. And he told me he was going to be here. So.
Okay. The ex parte order will continue. The court wanted a custody order today, but again, this matter was just filed in November, so put over January is not going to create a problem for the court's time performance guidelines. So, Pratt, are you still there?
Yes, sir.
Could you just simply add to your recommendation that the ex parte order of this court, dated November 21st, shall continue? Just so I'm reviewing this, I'll be reminded that there's an ex parte order. It's not yet in the court file. It was stamped on November 22nd. We need to get that in this file. November 22nd, it's not in here. Ex parte order.
I have it for the 19th. Oh, that's summons.
That's summons. This court entered an ex parte order on November 21st. Actually, it looks like the date of the 22nd, which granted mom exclusive possession of the child and basically suspended your parenting time, Mr. Stockard. So
I know.
I'm just going to notice this order during the matter that the ex parte order will continue. So have Mr. Schwartz file appearance and reach out to Mr. Fleming. All right, anything further than this afternoon, Mr. Fleming?
No, Judge.
Mr. Stockard, the allegations, and I'm not asking you to respond to them, but if in fact the allegations that you have are dealing with some alcohol abuse issues, what you should do is probably get an assessment and get involved in some type of program so you can address that. So you can alleviate any concerns about your ability to parent this child at a young age. So with that will conclude this matter. We can zoom out. Everyone have a good rest of the day. We'll send you a copy of this order, Mr. Stockard.
I appreciate it. You guys enjoy the.
For the record, this matter is before the court on the plaintiff's motion for entry of a custody and parenting time order. This hearing is being conducted via Zoom. Present is the plaintiff petitioner, Devon. Mr. Litwiller, are you present?
Yes, sir.
Okay. Okay, Mr. Litwiller is present. In addition, Attorney Adrian Eddings is present, representing the defendant, Mother Lauren Easter, and Ms. Easter is present. Good morning, Ms. Eddings.
Judge.
The parties have conferred this morning with Ms. Barr from the front of the court, who is right to the following recommendation. The parties shall share joint legal custody of the minor child. The issue of physical custody is reserved at this time. And this court's of the opinion that physical custody does not need to be addressed. It's simply joint legal. They can share equally any major decisions concerning the welfare of the child. And it's really just a matter of parenting time. In the event, the court will reserve the issue of physical custody. With respect to parenting time, the recommendation is that plaintiff father shall have parenting time on Fridays from 10 a.m. to 6 p.m. He shall notify mother today if he's scheduled to work on any Fridays pending mediation. The parties agreed to move his Friday parenting time to Saturday in the event he's scheduled to work. Father will have additional parenting time on Christmas Day from 10 a.m. to 6 p.m. Parties shall exchange the minor child at the Jasper Food and Fuel Store in Jasper, Michigan. And lastly, the parties will mediate with Mr. Walker these issues on the January 8th, 2025 at 1:30 p.m. Of course, the court will be available thereafter if the parties wish to place some agreement on the record or if they need an evidentiary hearing. Ms. Eddings, is this recommendation agreed with your client this morning?
Yes, Your Honor, I apologize. I might have heard you incorrectly. If Mr. Litwiller cannot do Fridays, he will do Sundays. I wanted to make sure it was Sunday, and I thought I heard you say Saturday, but it would be Sunday.
Correct. The court was mistaken. The recommendation is that parties agree to move his Friday print time to Sunday in the event he's scheduled to work.
Yes, Your Honor, and that is my client's agreement. We conferred in a separate breakout room and came up with that schedule, and Mr. Litwiller agreed to do so until mediation, where we can have a more permanent parenting time schedule after that time.
Thank you, Ms. Iddings. Mr. Litwiller, is it pronounced Litwiller?
Litwiller, Your Honor.
Mr. Litwiller, do you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting this as a temporary order?
What's that?
Do you have any objection to the court adopting this recommendation as a temporary order?
No, Your Honor.
Okay. All right, Ms. Easter, Mr. Litwiller, can you both please raise your right hand and be sworn, please? Do you both? And do you believe this temporary arrangement is in the best interest of your child?
Yes.
All right, thank you. Ms. Iddings, do you have any questions, Mr. Litwiller?
None, Your Honor.
If you could just please award Ms. Easter that she believes that, at least at this point in time, this agreement is in the best interest of the child, please.
Yes, Your Honor, I will do that. Lauren, we had a chance to discuss a proposed temporary schedule while we were meeting with Ms. Brower, correct?
Yes.
And the schedule that we came up and proposed is something that you talked about with me. Is that correct?
Yes, correct. That's correct.
And you believe at this time, at least for a temporary order, this is in the best interest of Carter to have this temporary order in place until we can get to mediation and discuss a long-term parenting time schedule. Is that correct?
Yes, I do.
And would you like the court to sign this temporary order and get it entered so that we have this temporary parenting time schedule ordered by the court and in place until we get one?
Yes.
All right, thank you. Those are the only questions I have for my client, Your Honor.
Thank you, Ms. Iddings. And of course, presumably at the mediation, the parties will also discuss child support.
Yes, sir. Yes, they will.
Right, the court would like to, the court finds this a recommendation to be the best interest of our child. The court will currently adopt the same. Copy mailed out to Ms. Iddings as well as Mr. Litwiller. Thank you, Ms. Barr, for your assistance. Mr. Litwiller and Ms. Easter, now is the time to start on the right page. There's enough challenges in life. Make parenting time schedule is good for you and your child. And communication is the key. So, Ms. Litwiller, it's really important that you keep mother informed of your work schedule.
Yes, sir.
And you should walk be on time. You don't want to be sitting in a vehicle with your child for any extended period of time. If there's if you're late, if there's a problem with traffic, please notify the other party.
Yes, sir.
So where is Fayette, Ohio?
Fayette is a few miles south of Morenci, if you know where Morenci is.
Okay. Generally, so Jasper obviously is is that in Lenawee County, Miss Iddings?
I think it's Lenawee.
I think it's Lenawee. There might be a portion of it that's actually in Hillsdale.
No, it's in
Okay.
it's in Lenawee County. It's right. It's just south of Adrian.
On the matter of child support, could I say something?
You can make a statement if you want, but we're not addressing that this morning. Well, we'd address it down the road.
Okay.
Go ahead, Mr. Litwiller, you have a question?
I filed for child support and the defendant denied it. I just want that to be known. She denied it.
Okay. Well, that's obviously subject to discussion. I don't know if the child's receiving public assistance, but we'll address that issue down the road to make sure that both of you support the minor child.
Yeah.
Okay, that will conclude this matter. We can zoom out. That will, thank you, Ms. Brower. Thank you, Ms. Iddings.
Thank you, Judge.
You're welcome.
Have a good rest of the day.
Okay, thank you. Lauren, I'm going to call you right after this, okay? All right, thank you, Judge. Have a great day.
Recommend the court enter an
Thank you,
order
Ms. Brower, for
dismissing
help.
the show cause action. Ms. Vlade, do you understand the recommendation?
Yeah, I do.
Okay, do you have any objection to the court adopting this recommendation? Ms. Vlade, do you have any objection to the court adopting this recommendation, dismissing your show cause?
I do.
Okay. All right, the allegation is that Mr. Lara is not paying child support. There's a verge of about $7,000. And Mr. Lara, you're currently on probation for felony non-support criminal charge. Is that correct?
That's correct.
Okay, and unfortunately, probation officers are more focused on offenders who have alcohol and drug addiction problems and convicted of dangerous offenses. Mr. Lara, how much are you ordered to pay? You're ordered to pay $407 per month by the criminal court. Is that correct?
That's correct.
Well, this is a civil court. And then we tend to enforce these orders more than the criminal court does. Have you been paying $407 per month on a regular religious basis?
Yes, sir, except for the exception of the month of October of this year. I've made partial payment of around 50%.
Okay. Did you make the full payment for the months of November and December?
I haven't for December just yet, although I do plan on making that towards the middle or late of December.
Ms. Patrick, the average is about $7,000, is that correct?
Not at this time, Your Honor. As the payments are being made, the current is being paid. There's money falling on the arrears. As of the last day of November, the arrears are $6,742.41. Mr. Laura is reducing those arrears, sir.
Okay, is there an income withholding order in place?
No.
Okay,
Hang on a
Mr.
minute,
Lara,
Your
are you currently employed, Mr. Lara?
Yes, sir.
Okay, with whom?
With a company, it's a private owned company in Lexington, Kentucky.
That would be why there's no current IWN, Your Honor, because he is out of state. He is making the payments on his own.
Can we enter an income withholding order, Ms.
Can I
Patrick?
step in?
If we
Can I
register
step in
as an
this
interstate order, Your Honor.
Just a minute, I'm sorry, just a minute, Ms. Blade. Ms. Patrick, is it possible that we can enter a next income withholding order to an employer in Lexington?
If we register the case as an interstate, Your Honor, then yes, we can put it in as, we can request the state of Kentucky to get an IWN against him.
Okay, so that's a process to register this order in the state of Kentucky. Is that correct?
Correct.
And Mr. Lara has been voluntarily making the payments?
That's correct, Your Honor.
Okay, and then a little short for the month of October. All right, then Ms. Blade, go ahead. I was just asking some of the questions of what it takes to get an income withholding order to come direct off his paycheck. It seems it's very cumbersome. You can always have a private attorney you seek to file to register this court order in the state of Kentucky, but we still have to rely upon Mr. Lara making voluntary payments. And he seems to be making some progress, Ms. Lara, but go ahead. Ms.
So
Lara, you still there?
I'm sorry. Who are you asking to speak to?
You had some questions, and I wanted to hear from Ms. Patrick first. So you had some questions or comments?
Yeah, I do. I think you should benefit by giving his probation officer a call because he no longer works in Lexington, Kentucky. Yeah, as of 2 weeks ago, speaking to his probation officer, he is without a job, sir, and most likely a vehicle because they live in Richmond and not in Lexington anymore. Mr. Lara seems to fabricate a lot of his stuff, and I usually hold a good report. And I'm not trying to be rude, Your Honor, but if you have these stipulations in place for Mr. Lara as to having a permanent job placement, not a temporary day job, if you have him in place to make sure he's honoring his payments, which last month he made a partial, which put me in jeopardy of an eviction, I had to have my pastor step in and help out because he did not honor his payment last month. So is that we're just putting a slap on the hand to Mr. Lara to let him pick and choose the amount of what he can pay. He's already had 3 probation officers. He's given a P.O. box because he doesn't want to give his official address, which his probation officer has no issue giving me. Mr. Lara likes to try going against stuff. So, I mean, overall, if you have these stipulations in place for a felony probation for an individual and we're just walking around it, it's more so like a slap on the wrist and he can do what he wants. I need you to sit there and validate that his employment is valid, that he is working a job and not just saying to say it so he doesn't get picked up. Because per the conversation with this PO, it's a completely different story, Your Honor. It needs to be thoroughly investigated. Mr. Lara likes to lie and exaggerate a lot, and he's not countable for a majority of the time as permanent placement for work. He's put me in a position as a parent while I'm in graduate school. I'm on restricted income. Okay, I'm not trying to do a pity party here, but every penny that I have accounts for all of my bills and everything, and he's already jeopardized my rent last month because I put everything that I have for my money towards the beginning of the month, and I count my child support at the end of the month to go towards my rent because I pay everything in advance. So I just would appreciate if someone could thoroughly investigate it instead of just saying you're not going to recommend an order to pick him up when he is clearly in violation of the stipulations you outlined for him when he was there in August. And he has not met them because he has been bouncing around with 3 to possibly maybe 4 within the next month for a 4th PO if he can't seem to find work or a stable job or a stable place to live. This is his behavior. Thank you.
All right, thank you, Ms. Blade. You understand the criminal court can slap Mr. Lara much harder on the hand than this court can do. I'm the family court judge. I'm not the criminal court judge. So the probation officers do not answer to this court. Hold on, Ms. Blade, we're talking over each other. Let me finish my statement, and then you can respond. The criminal court can slap Mr. Lara much harder on the hand than this court can do. I'm a family court judge. I can only hold Mr. Lara in the contempt court, punch by a maximum 45 days in jail. The criminal court judge can send him to prison.
That's what I assumed that I was filing the paperwork for, sir. I was not asking for friend of the court. I spoke with Tiffany Mathers, and she said I needed to file a form to have it seen before felony court.
That's correct, but if the probation officers won't put pressure on Mr. Lara, this court can't do anything. Those probation officers report to the criminal court judge, not this family court judge. So it's, and again, and if he's going through probation officers, they're more focused on the serious crimes rather than filling out support. The most this court can do is impose a 45-day sentence, and which could cause Mr. Lara to lose any job he's got. But we'll take some testimony, Mr. Lara, regarding employment. Mr. Lara, raise your right hand to be sworn.
Address. I would actually like to not release that information right now. If you'd like to have a private conversation, I will be more than happy to give that to you. But as far as now, I absolutely do not want Ms. Valade to have my address, my current address.
That's fine. Ms. Patrick, you have an address for Mr. Lara, correct? I'm sorry, I couldn't hear that.
We do, the front of the court does have a address on file for Mr. Lara.
All right, so you need to keep the front of the court form and change of address, Mr. Lara. Now, the court file reflects an address in Richmond, Kentucky. That's where you were mailed a copy of this motion in notice hearing, correct?
Correct.
Okay, so what's important, yes, if you want a confidential address from Ms. Valade, that's one thing, but you need to keep the front of the court informed, because, for example, if they send out a notice to a peer probation officer, they need to, and you don't get that notice because you changed your address without informing them, that's when bench warrants issue. Anyway, Mr. Lara,
Your Honor, actually, I have in fact had the second I had moved from Lexington, I had informed the front of the court about my new address change, and I have documentation for this via email.
Okay, so you got a new address, that's fine. So, Mr. Lara, the next question is: are you currently employed?
Yes, sir, I am.
With whom?
With again, this is a company that an address.
What's the name of the company?
Can I give you this information without Ms. Valade hearing it?
No,
what's
sir,
that?
no,
Okay.
because we want you to catch up on the support you missed.
Right.
So the probation officer won't do this, but this court will do so, Mr. Lara. What's the name of your current employer?
It's called Ad Color. It's spelled ADCOLO 31046.
Are you employed full time, Mr. Lara?
Yes, sir, I am.
And do you get paid every week or every 2 weeks?
Bi-weekly.
Okay, what's your take home every 2 weeks?
It's about the close to 1,600.
Take home?
Give or take about maybe about 1,000.
Okay. And your probation only requires you pay $407 a month. Is that correct?
More or less, yes.
Well, that seems like pretty low based on your income. Ms. Patrick, of course, once a criminal court takes over, we didn't. This court and the front court does not establish an amount by which Mr. Lara pays. Correct? Do we essentially take a second backseat to the criminal court?
That's correct, Your Honor. We're going to monitor what the felony charge stated and what that order stated. That's what the front of the court is going to enforce.
So can this court increase? This court cannot increase that amount. Correct? They can only enforce that he's paying the ordered amount.
The court could increase the amount, but realistically, you can only enforce what the felony said. But we could increase his IWN, but I'm not sure what action we could take if he didn't pay it, because we would have to go back to the felony order.
Well, I can order
That's entirely fine with me.
Hold on, Ms. Blake.
I'm sorry. No problem. Sorry.
Ms. Patrick, this court can order Mr. Lara to personally appear for contempt. Is that correct?
That's correct, Your Honor.
So if he does not pay an amount, it appears that he can pay more than the $400 a month. Is your current support being charged, Ms. Patrick? Is it all arrears?
The current support is $192 a month, Your Honor. That is being paid. And for the month of November, he paid $243 on the arrears.
So he paid $600 in the month of November. Is that correct?
It was $192 and $243, Your Honor.
Okay. So he paid the amount ordered by the criminal court, but he missed. He's still delinquent with respect to October.
October, he paid $192. So he paid the current, but the arrears payment was only $8.
Patrice, the arrears payments are over $207. He's ordered to pay $407 a month. Per felony, it is $189 as in regular child support, and his arrearages are over $200 every month that he is supposed to follow up on.
Your Honor,
He's almost $7,000 behind.
Your Honor, can I make a few statements on this matter, please?
Go ahead, Ms.
You can do so privately since you like to verbally insult people.
Ms. Valade, I cannot hear two different people at one time. So are you done speaking, Ms. Valade? Then I'll let Mr. Lara respond.
Okay, so yeah, there's a few things I need to clarify. Ms. Valade has been spreading a lot of misinformation so far. The first thing I need to address about the matter of my partial payment of $196 in October. There's actually a reason for that. Long story short, I had to relocate out of Lexington, Kentucky. Apparently my apartment landlord, she has zero tolerance to house and to rent to convicted felons. And I have my speculations as to who had notified my landlord about this, but I'll spare you that. I don't have any proof that Ms. Valade did it, although I can speculate. In either case, Your Honor, the landlord she had given us a 14-day notice of eviction for us to leave the premise in Lexington. 14 days. That's 1-4, not 4-0. It's not 30 days, not 90 days. 14 days to leave the premise as soon as possible, with no exceptions. This was back in early October of this year. So I'm sure you can imagine it's been really stressful for myself, my current fiance, and my other child that I do live with, for us to just pluck her out of school, for me to find a place of residency, to find a home ASAP as soon as possible. We have then 14 days to evacuate the premise. So during that time, I was fortunate enough to find an apartment building here in Richmond, Kentucky. And we spoke to the landlord and everything, and she says that because my felony charge is nonviolent, has nothing to do with any kind of sex crimes or drugs or anything violent. She said that it was fine for me to be a resident here in Richmond, Kentucky. So long story short, the reason for my mispayment, well, it wasn't a mispayment, it was more that I paid half.
Hey, Mr. Lauer, that's all fine and dandy. It's not really a short story you're telling the court. It's a pretty long story. I want you to catch up what you missed.
Yeah.
So you're behind by $200. You missed. You only paid half of the month in October.
Well, yeah.
Do you have any bank accounts, Mr. Lara?
No, not at this point. I mean, I do receive checks for my job, but I cash them.
Mr. Lara, this court is not concerned about your fiance or a child from another relationship. This court's only concerned about the child that was born to you and Miss Lade. That's all.
Right.
It's $1,600 every 2 weeks. You should be able to pay more than $4 a month.
I wasn't making that then, Your Honor. I actually just started this job about less than a week ago, just right before the holidays. And I mean, it was.
Hold on, Ms. Lara. You said you bring up $1,600 a week. We just started the job. $1,600 every 2 weeks. We just started a week ago.
No, it's I've been working for this company through a temp agency, but I was just hired on as a permanent position about a week ago, just before the holidays.
Okay, to add ad calor, correct?
Right, that's correct. Yeah.
Okay. All right. So do you expect the same income from them now that you're an employee, $1,600 every 2 weeks?
Sure. Yes, I do.
Well, probably more because the temporary agency would have taken something out of your paycheck, correct?
Yeah, I mean, I don't know exactly what they'll want from me, but I do know that it's probably going to be just a little bit more. If I can assume, it's maybe about $1 or $2 more, if that.
Okay. Well, the court wants you to pick up and pay before the end of this month what you're behind on. Especially the way you can tell how short he was in what months for the $407.
Your Honor, the only one in June he paid the $192 and the $8. In July, he paid the $192 and $228 for the arrears. August, he paid the current $192. He paid $228 on the arrears. September, he paid the current $192. He paid $228 on the arrears. We have October, he paid the current $192 with only $8 on the arrears. And then November, he paid $192 with $243 on the arrears.
Okay, can you tell me how much he's short during the period of time he's been placed on probation from paying the full $407 a month?
I don't have the probation order right in front of me, Your Honor. If you have that date, I could probably figure it out.
Mr. Lar, when were you sentenced? When did your probation order require you start making these 407 monthly payments?
I believe it was in 18th of July this year.
Okay. So your first $407 was due in July of 2024. Is that correct?
Correct.
Okay. Ms. Pettit, can you approximately how much is he short since July?
Hold on, Your Honor, and I will do that math for you. Your Honor, by my calculations, it looks like he could be short $155.
Okay, certainly not significant. So, Mr. Lark, you need to pay an additional $155 for the month of December. You've not paid anything for December yet. Is that correct?
That's correct. Not just yet.
So, what the court's expect to do is pay $562 for the month of December. The 407 plus the 155 that you're short.
Okay.
Right. The court can order Ms. Valade that Mr. Lar pay $562 for the month of December. That catches him up per the criminal court order. I'm not sure what more the court can do beyond that, Ms. Valade. Your attention is better directed to the criminal court judge and the probation officer. They can put him in. They can give him jail time if you have to comply with this. But that's
how
the
would
order.
I go about that, Your Honor? I originally thought I was filing for felony. I apologize.
And talk with the probation officer, bug the probation officer to bring back for the criminal court judge. But again, the judge will only do something if he's not paying the 407 a month.
Okay, and then my only other question is, how do we go about putting an order in place to increase the child support, even though the felony shows that he has a temporary
motion? If you want to modify the current support beyond over above the 192, and probably you should do that because Mr. Lar now has a better paying job, you can file a motion with this court to modify child support. And the front of the court will conduct an investigation to get some financial information, Mr. Lara. And yes, you can increase that 192.
I'll probably do that after the new year, so he has at least a few checks or pay stubs on file for them to review. But I appreciate your help. Thank you.
All right, so the court will simply in order that the show cause will be dismissed upon Mr. Lara paying $562 for the month of December.
I'll do
Ms. Patrick, can we, so in other words, if he pays that, then the show cause is dismissed. If not, we can bring Mr. Lara back for the court. But we're not gonna set another, we will not set another review date at this time. So Mr. Lara, make a note, 562, you got to pay that the month of December. And keep in mind, obviously, that the Ms. Blades may very well file a motion to increase your current support. So you want to keep making progress toward these arrearages.
Okay. I'm not too thrilled on the idea of having this my support being raised.
That'll be before the court on another date. It's based on your income. Based upon your income. So if you got increased income, it may go up. And of course, it may, if Miss Blade has an increased income, it may go down.
Okay. I don't really understand how is this determined. I mean, I live in Kentucky. We have a different wage.
Right, there are guidelines. There are guidelines. Right. So if Miss Blade files a motion to modify child support, you have a chance to talk with the front of the court, and the front of the court will go through with you the guidelines based on your respective incomes.
Okay.
And number of overnights that you have with parenting time. Presumably you're not exercising any overnight parenting time.
I can't exercise anything. She blocks me from all, phone numbers, addresses, emails.
You can file a motion for parenting time, Mr. Lara.
How do I go about doing that? Do you know who do I speak to?
Call a caseworker at the front of the court. The front of the court will tell you who your caseworker is, and you call a caseworker and go online, get a form motion for parenting time.
You can also get the forms off the Monroe County Front of the Court website, sir.
Thank you. I appreciate that. I will be doing so very, very soon.
All right. So the court at this time will enter an order that this show cause will be dismissed upon Mr. Lara paying $562 during the month of December 2024.
Okay, we'll
Any
do.
Questions, Ms. Blade?
Yes, Your Honor.
Do you have any other questions, Ms. Blade?
No. Am I allowed to stay on the phone call with Patrice afterwards?
I'm sorry, you want to stay on the phone with Ms. Patrick?
Yes. I wanted to review my parenting time that's already currently and has been in place for the past 6 years.
You talk with your caseworker. You have a caseworker assigned to this file. That's to be the person to talk to.
Well, it seems as though the state doesn't know how to correctly file me with the correct caseworker, because every time I go in the office, it's always someone different, or they're not available, or I've reached Miss Patrice via voicemail 4 times in the past month with no response.
Okay. Well, let's give you your case number. We'll give you the phone number and the email address. Ms. Patrick, can you advise the parties who your caseworker is?
Your Honor, I will give Ms. Blade my personal number and my personal email, and I can assure the court that I have responded to her and I will respond to her. So my personal phone number is address.
That's what on the card. I have that information. It's on the card in front of me.
Okay. All right. With that, that will conclude this matter. Mr. Lara, please make sure you make that payment 562 this month.
I will.
All right. That will conclude this matter. You can now zoom out. A copy of this order we mailed to both of you. You can zoom out.
Thank you.
Have a good rest of the day. Thank you.
Bye-bye.
Thank you.
Morning, Your Honor.
All right. Have a nice one.
Mr. Johnson, have you reviewed the proposed qualified domestic relations order submitted?
I have, Judge.
Any objection?
None.
Right, Ms. Hills, that will resolve the matter. I don't know, Mr. Johnson, are you going to approve the quadro, or I guess you can note for the record that you, Mr. Rister is present. You have no objections to it. It does appear to be consistent with the judgment of divorce. So Ms. Hills, I don't know if you want to chat with Mr. Johnson. Will you just submit that to the court? I don't think you need his approval.
Well, I would be happy to do that if I would sign his name if he gave me permission, but I agree with the court.
Yeah, sure. If you could just let me take a look at it, that would be great. But other than that, yeah, I'd have no objection to that.
Good. Do you have a copy of Mr. Johnson?
It was attached to the motion.
Oh.
Do you want to go into a breakout room for a couple minutes to make sure it's acceptable so that Mr. Johnson can give his approval to you, Ms. Hills, to approve it? Like
Yes,
to
Your Honor.
avoid any delay.
That's fine, Your Honor. Thank you.
Give Mr. Johnson a few more minutes to take a look at it.
Thank you, Judge.
Welcome.
Your Honor, the updated Laura recommendation is in your queue.
Do you think, can we add something to that? That just maybe put I'd like to reference a total. I think it was what, trying to recall the amount so that there's no confusion, because that 218, that's just the arrears. So the total amount was, 407 plus the 155 years short. So total 562. Maybe you can put in parentheses, total $562.
I did on the new one, Your Honor. It reads, show cause is dismissed upon payment of $562 for the month of December being current child support and arrears payment.
Gotcha. Perfect. That's clear. Thank you. I'll go ahead and sign that. Thank you.
Thanks.
Christina Hills is present with the plaintiff, moving party. Attorney Kim Johnson is present with the defendant. The matter before the court is entry of a proposed qualified domestic relations order. Mr. Johnson, have you had a chance to review that order, that proposed quadro?
I have, Your Honor.
And as your client, and you have any objection to Ms. Hill submitting that to the court for entry?
There's no objection, Judge.
Right. So Ms. Hills, you can simply just indicate that it's been approved by Mr. Johnson and submit that to the court timely.
Yes, sir. I will.
All right. Anything do you want to make voir dire your client, Mr. Johnson? Is it necessary?
No, it is not, Your Honor.
Right. Right. The court will note both parties are present. Anything further than this morning, Ms. Hills?
Not this morning, Judge. Thank you.
Okay. All right. So you can submit that to order. All right. Thank you, Mr. Johnson, for appearing this morning. That will conclude this hearing. Now we can zoom out. Have a good rest of the morning.
Thank you, Your Honor. You too.
Thank you.
Course, indicated that the defendant, Ms. Brister, was awarded, the plaintiff, Renee, was awarded the survivor spouse benefit to his GM pension.
Okay.
I don't know why it wasn't done back in 2017 when the judgment was entered. Well, either way, but I'm just normally, all right, you can hang out, ma'am. No.
I didn't know.
Yeah,
I guess I just assumed that with the judgment of divorce, the quadro was not given.
No, you've got to enter a quadro
Okay.
in addition to the judgment.
Okay.
Because because it's under federal law.
Yeah.
So that it's not allows it to divide the pension. So he gets a full pension, but he chooses more just a survivor benefit. So if in fact he passes,
Right.
I mean, if she preaches him, she gets nothing. She'll get nothing in terms of current, but if he passes or remarries, she'll have to get a survivor benefit. Won't go to his new wife or to his estate or anything. So why they didn't do it, you should normally do it right in the heels of the judgment.
Right.
Find up those loose ends. So judgment just says a quadro will enter. It's never
But a
submitted.
quadro can't just like come up to you like in an ex parte kind of way.
Well, in this case,
They have to
obviously,
go on the record.
it happened so long ago. I don't know if Christina reached out to Kim Johnson, but it's been Kim Johnson. Did you represent her in him in the divorce?
I'm asking most.
Probably because so much time,
reference.
probably a lot of times they are submitted by consent.
Right, okay.
And
So
Kim
that's what I
Johnson
assumed.
was the attorney for him back then, but it's been so many years. She probably just assumed that he
Okay.
was not still active in the payroll.
Okay. The answer is
Again,
no.
he didn't respond to it at all, but obviously he suggested he'll be pairing with his client.
Gotcha.
So Christine Hills didn't know, but the quickest way to get entered is just file the motion
Gotcha. Okay.
and serve the other side.
Yeah, understood. Yeah, that makes sense.
For the record, Mr. Michael Tumanello is appearing via Zoom from the Monroe County Jail. Also present is Attorney Timothy Leiter, previously appointed and renewed appointment to represent Mr. Tumanello. Good morning, Mr. Leiter.
Your Honor, good morning, sir.
Also present for this Zoom hearing is Monroe County in front of the court attorney Rebecca Hicks. Mr. Leiter, Ms. Hicks and Mr. Tumanello reminded the court, refreshed the court's memory. Mr. Tumanello was ordered to appear, I think, May 6th. And he contacted the court and he was still working. So we adjourned it they told him to appear the next day. That was back in May of 2024, a number of months ago. And he never did appear, never followed up, wasted a lot of the court time and resources. And you, I believe, appeared on May 7th. Mr. Tumanello never appeared, waited to get picked up in the bench warrant. Mr. Tumanello is present this morning. If you had a chance to talk with Mr. Tumanello.
Your Honor, I had a chance to talk to Mr. Tuminello about this case. I advised him of the potential plea offer that Ms. Hicks has put forth, and I'm sure she'll place that on the record. Mr. Tuminello wishes to admit to the allegation. The only variation here, if that, is he wishes to make a bond reduction request at the end.
Okay, thank you, Mr. Leiter. Mr. Tuminelli, are you satisfied you received the right to legal counsel by conferring with Mr. Leiter?
Yes, Your Honor.
Okay, Ms. Hicks, what is the offer you've proposed?
That Mr. Tuminello would admit to contempt, Your Honor. He has now been in the Monroe County Jail for 5 days and would be entitled to 5 days jail credit. Front of the court requested 10 days immediate jail credit for those 5. My initial request was going to be that his bond remain at $500. I know from speaking with Mr. Leiter that they are going to request for a reduction of $250. I will note that the front of the court is not opposed to that reduction, Your Honor. That would cover at least 1 month's current support obligation. And I will note that he did tell us that he was currently employed and would still hopefully have that job when he leaves the jail. And I will note that we've already had sent an income withholding notice to that employer that he had provided on the record. So I would not be opposed to a reduction to $250 in lieu of that remaining balance of 5 days.
Okay. All right, so Mr. Tuminelli, the court's inclined to follow that recommendation and allow you to post a $250 cash bond and to avoid any of the additional 5 days in jail. Do you understand that?
Yes, Your Honor.
So based on that representation, is it true that you're willing to admit to contempt?
Yes, yes.
And you understand that finding contempt, the court will give you credit for 5 days, but you have 40 days hanging over your head. And if
yes, Your Honor.
If you so the court's handing you the key to the jail, because if you fail to comply with the orders in the future, you're buying yourself some jail time. Understood?
Yes, yes, Your Honor.
Right.
Whenever you're, is it okay to talk when you get a second? I just gotta note one thing real fast, please. If that's okay, sir.
Go ahead.
So my money, I got paid from work yesterday, or I get paid today. It should be on my account. It's in my property. Is there any, I don't know how it works around here. It's very hard to, I can get a majority of the money I have right here, right now. It's right next to me on my phone.
Unless you have
Is there any
cash in
way
your
that-
property, no. They're not gonna let you out of jail. You have to go down to the bank and use your card.
No,
Mr.
I understand.
Tuminelli.
I understand. Is it okay to get
So
it?
someone needs to come in
my
and
mom?
post cash, $250.
Okay, yes, that's of course, that's fine. I just wanted to see if someone could pick up my property just to get it off my debit card.
Your Honor, we'll unroll the policy when we're done here.
Okay, thank you. That's all. I'm sorry. Go ahead. I apologize.
All right, so Mr. Tuminelli, raise your right hand to be sworn, please. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Please state your name and current mailing address.
My name is Michael Anthony Tuminello.
Mr. Tuminello, you admit and acknowledge that you ordered to pay child support for the maintenance of a child or children born to you and Brittany Howard.
Yes.
You admit and acknowledge you have arrearages about approximately $5,700.
Yes.
Do you admit and acknowledge you've not made any payments since August of 2024?
Yes, Your Honor.
Do you admit and acknowledge you've had income since your last payment in August and you've not paid that toward your child support obligation?
Yes, Your Honor.
Mr. Leiter, do you have any questions of Mr. Tuminello?
No, Your Honor, I do not.
Ms. Hicks, do you have any questions of Mr. Tuminello?
No, Your Honor, I do not.
Very well, the court finds that Mr. Tuminello does have a support obligation. He's acknowledged that. He acknowledges having arrearages in excess of $5,000. He's had income since August 2024, has not paid any of that toward his child support obligation. The court finds his lack of due diligence to be a basis for contempt. It currently finds Mr. Tuminello in contempt of court. The court's inclined to follow the recommendation of Ms. Hicks. Mr. Leiter, is there anything further?
No, Your Honor, we again certainly do thank Ms. Hicks as well as the court.
Thank you. Mr. Tuminello, anything you want to say before the court imposes a sentence?
I would just like to say thank you all, and I apologize. And this will be the last time you see me. I promise. I do appreciate all your time, and I'm sorry about any problems I've caused before. But I will make all this up. I promise. And I do apologize, Mrs. Hicks, from not understanding fully, but I do now. And I just want to say I'm sorry. And I will make sure, no matter what, that I will keep you guys in the loop and I will make sure to make my payments. And I appreciate everything you guys do for me.
Right. No need to apologize, Mr. Trumanello, but just, yes, we just keep staying in the loop. That's all we're asking. Be proactive. If you, hopefully you have that job with Guarding Glass, but if you don't, you need to talk with front of the court and file a motion to modify support. Just be proactive. Keep contact with Ms. Hicks. In any event,
You're right.
You're
right, Your Honor, and I apologize. And I will do
no need
that.
to apologize. Just take care of business, Mr. Trumanello. That's all we're asking.
Yes,
So
sir.
the sentence court is you're to serve 45 days in the Monroe County Jail as follows. 10 days immediate. You're given credit for the 5 days you have served. You can avoid the additional 5 days by posting a $250 cash bond. So if we get that posted today, Mr. Trumanello, you'll be home for dinner. If not, you're serve the next 5 days in jail. You get credit for that time. But keep in mind that hopefully if you're out today, you still have 40 days hand over your head. And you can avoid that by simply getting on board. So make some phone calls today. I don't know if the jail will release your personal property to a third party. Have someone come up post it and you can reimburse them once you get to the bank with your card.
You're right. And I'm gonna find out from the CO when he says after I hang up with you. So thank you all. And I apologize for everybody, but thank you all for at least accepting my apology and showing me what to do from here on out. I will keep you guys in the loop. And I truly am sorry. And thank you all for your help.
Finally, sir, we're going to give you a date to appear before Ms. Hicks after the first of the year for review. Mr. Later is excused. He's not required to appear at this review hearing. Ms. Hicks, what do you recommend for a review date?
January 28th at 10 a.m.
I'm sorry, what month?
January 28th at 10 a.m.
Thank you. I know sometimes with your microphone being on one side, your screen the other, we don't always pick up some of that when you're moving. So, Mr. Trumanello, you're to appear before Ms. Hicks, January 28th at 10 a.m. for review. If you're working, you can step out and you can appear by Zoom. All she wants to know is that you're making your payments. Okay?
Okay, that is fair. And I will make sure that I keep everyone in the loop no matter what. And I will be at this court date.
All right, the copy of this order will be mailed to you, and one copy will also be faxed over to the county jail, so you get a copy of it when you're released.
Yes, Your Honor.
All right, any other questions?
No, sir. Thank you so much for your help. I appreciate it.
You're welcome. Thank you, Mr. Laird. That will conclude this hearing. You can step out, Mr. Trumanello, and that will conclude this hearing.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor. I'm just uploading that order to your queue now, and it should be set.
Okay.
Thank you.
You're welcome. That's any other cleanup matters?
No cleanup today, Your Honor.
Okay.
Thanks.
Calling the matter of Rebecca Muster versus Nicholas Muster.
For the record, this matter is before the court on the plaintiff's motion for temporary orders. This recently filed divorce action. This hearing is being conducted via Zoom. Present is Attorney Cameron Irvin, standing in for Attorney Kim Kuhn this morning on behalf of the plaintiff Rebecca Muster. Ms. Muster is present. In addition, Attorney Kevin Kajewski is present, representing defendant Nicholas Muster, and Mr. Muster is present. Good morning, everyone.
Good morning, Judge. Good morning, Your Honor.
The parties have conferred with Mr. Pratt from the front of the court this morning, and the court has been provided with the following recommendation: that the ex parte mutual restraining order shall remain in effect. Further, that the parties shall maintain all marital bills per the status quo. Defendant Nicholas Muster shall have the Amazon Prime card unlocked so his wife has access to it. The defendant, Mr. Muster, shall also provide proof of any settlement money in the joint bank account. Neither party shall spend outside of normal spending from the joint Comerica checking account. Finally, the parties will mediate with Mr. Pratt on January 31st, 2025, at 1:30 p.m. via Zoom, and subsequently appear before his court for a pretrial conference. And if this recommendation is agreeable, then the pretrial conference of January 9th will be vacated. Right, Mr. Irvin, is this recommendation agreeable with your client this morning?
Yes, Your Honor. After speaking in front of the court, we just ask that you adopt the recommendation.
Thank you. Mr. Kajewski, is this recommendation agreeable with your client this morning?
Yes, likewise for us, it's agreeable and we have no objection.
Thank you. Obviously, both parties participated in the discussions with Mr. Pratt this morning. Do counsel wish to voir dire their respective clients regarding the recommendation? Mr. Irvin?
Sure.
It's up to you. The court's not recording it. The court notes that both parties did participate. They presumably have full knowledge of the recommendation. But if you want to, the court can swear in the parties if you want to voir dire. So,
Your Honor, I don't think that's necessary. I think we all had an understanding. And Rebecca, you're comfortable with the understanding of the adoption or the friend of the court recommendation. I don't think it's necessary, Your Honor.
all right, thank you. Mr. Kajewski?
No, likewise, I think we're good. You're okay, Mr. Mester?
I am.
All right, thank you.
All right. All right, the court would like to thank and acknowledge Mr. LaPrade as well as Mr. Irvin and Mr. Kajewski for helping facilitate this initial temporary amicable resolution. And with the adoption of this, the court will vacate the pretrial conference of January 9th at 8:30. Mr. President, possibly we can add that language to this so it's real clear. Just says a clause saying the pretrial of 1/9/2025 is vacated.
Oh, yes, sir.
That'd be wonderful if that can be added without having to redo it. All right, that will conclude this matter. Mail out to council. We'll serve then on January 31st at 1:30 or after the 1:30 mediation. All right, that will conclude this matter. Everyone can zoom out and have a good rest of the day.
Thank you very much, Your Honor.
Thank you, Your Honor. Have a great rest of your day.
Thank you.
Versus Elizabeth Desjardins.
For the record, this matter is before the court on the plaintiff's objection to a referee recommended order providing defendant mother with unsupervised parenting time on November 30th, which is already gone. That was the Thanksgiving timeframe. This hearing this morning is being conducted via Zoom. President's attorney Dominic Hamden representing the plaintiff father Matthew Desjardins. Mr. Desjardins is present with Mr. Hamden. Good morning, Mr. Hamden.
Good morning, Your Honor.
Also present is the defendant mother Elizabeth Desjardins. Parties have conferred with Ms. Brower in front of the court this morning. The court has received the following recommendation. The recommendation is that referee recommended order be adopted but modified. That defendant mother's parenting time shall continue at Family Council Shelter Services. Defendant mother shall have supervised parenting time on Christmas Eve, 1 p.m. to 5 p.m. at plaintiff's home, plaintiff father's home, supervised by the plaintiff's mother, namely the paternal grandmother Bernadine Miller. And the plaintiff shall vacate the home during defendant's parenting time for those 4 hours. Further, neither party shall discuss this case with the minor children who are 12 and 8 years old. Neither party shall consume alcohol prior to or during parenting time. Further, the minor children shall be enrolled in counseling. The parties will appear back before this court to review mother's parenting time on January 15, 2025 at 9:30 a.m. via Zoom. And the defendant's motion for parenting time scheduled before referee Homrick tomorrow, namely December 5, is to be vacated and canceled. That's the recommendation. Mr. Hamden, is this recommendation agree with your client?
It is, Your Honor.
Right. Mr. Desjardins, do you understand this recommendation?
I do, Your Honor.
And if the court adopts it, it'll become an order of this court. Do you have any objection to the court adopting this recommendation?
No, Your Honor.
Okay. Right. Mr. Hamden, do you want to voir dire your client? Obviously, he did participate in the discussions.
I do not, Judge. I've been representing Mr. Desjardins for several years now, and he understands what the agreement was.
Thank you. Mr. Desjardins, do you have any questions?
No, sir.
All right. So again, contact Family Council Services and let them know if, and again, I don't know if you've tell them that's going to continue so they can schedule those continued sessions. Very important you have regular contact with the two children. And hopefully you are addressing some of the concerns the courts had.
Yes, Your Honor.
In terms of alcohol use, are you still involved in still attending AA meetings?
I never did. No, sir. Your Honor, I don't use alcohol. I haven't used alcohol in 4 years.
Okay. 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 Are you staying clean of any controlled substances?
Yes, sir. Yes, sir. Yes, sir.
Okay. What about, I know there's a legitimate concern about you're living with a victim of your domestic violence. Is that still the situation? We need to make sure the environment is appropriate for the children.
The environment's fine. There are other children in the home and there was no domestic violence.
Okay. Well, hope you're addressing the issues that have been raised.
Yes, Your Honor.
Right, the court will adopt the recommendation and we'll We'll review again mom's parenting time to January 15th at 9:30 a.m. Anything further than this morning, Mr. Hamden?
No, Your Honor.
Right. That will conclude this hearing. You both know the copy of this. And hopefully things will be, keep things good for the children on Christmas Eve. Hopefully there'll be no drama.
Please and thank you.
And who's going to initiate? Mr. Jardin will initiate the enrolling the children in counseling. Is that correct, Mr. Hamden?
Yeah, they will, Judge. He will, Your Honor. I'm only aware of one in his area, and I believe she is booked and doesn't have any availability. So we'll look around, but we will find somebody in order to commence that.
Thank you. And obviously, once he finds counselor, you should inform mom just as a courtesy who the counselor is and how often they're meeting.
Yes, Your Honor.
Okay, right. Thank you all. The court will adopt the recommendation. We'll see everyone back then on January 15th, 9:30. Thank you, Ms. Brower, for your assistance this morning.
You're welcome, Your Honor.
Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
With Ms. Sikorsky. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
For the record, this court did enter an expedited order scheduling this matter for hearing, but gave Mr. French an expedited hearing, but denied the request to suspend the defense parenting time. Mr. French, as protective services or Wyandotte Police Department taken any action relative to this alleged grabbing of the child's arm by the defendant mother?
Your Honor, you dispatched with this already at the previous hearing. The only thing that was before the court today was the defendant's motion to clarify and dad's motion, the plaintiff's motion to address child support.
Okay, thank you. Is that correct, Ms. Sikorsky? Is that your understanding as well?
Yes, that's correct.
Okay, thank you. All right, the parties have conferred this afternoon, I should say, with Ms. Brower from the front of the court, who's provided the court the following recommendation. That the parties shall share week on, week off parenting time. So we have a specific parenting time schedule, week on, week off, with exchanges to occur on Fridays after school. If there's no school, the party shall exchange minor child at 6:30 p.m. The party exercising parenting time shall be responsible for transportation. The parties are responsible for their own daycare costs during the school year. During the summer, the parties shall share daycare costs as follows: defendant, a mother paying 48%, plaintiff father paying 52%. Child support shall be abated as of December 31st, 2024, and all arrears owed to the defendant shall be waived as of January 1st, 2025. For tax purposes, defendant mother shall claim the minor child as a defendant for tax purposes on even tax years. Father shall claim the child on odd years. All communication between the parties shall be via app close. Party shall remove plaintiff father shall remove his fiance from the party's app close account. It's just between the parents. All agreed upon extracurriculars for the children shall be shared 50-50. If the parties cannot agree upon a certain extracurricular activity, hopefully they can, then the party signing it up the child shall be responsible for the entire cost. For agreed upon extracurriculars, the parent incurring the cost shall request reimbursement through AppClose, and the balance should be paid within 14 days. Any registration by the parent for extracurriculars shall include both parents' contact information. That is the recommendation. Mr. French, is this recommendation agreeable with your client this afternoon?
Yes, Your Honor.
Thank you. Ms. Sikorsky, is this recommendation agreeable with your client?
Yes, Your Honor.
Wonderful. The court appreciates your time and discuss this matter in detail with Ms. Brower. Both parties have participated in the discussions. The counsel, do you wish to voir dire your respective clients? If so, I'll give you the opportunity.
We'll waive voir dire, Your Honor.
Ms. Sikorsky, do you want to voir dire, confirm this with your client?
I'll waive voir dire as well.
All right. Very well. The court would like to thank Ms. Brower for her assistance, as well as, of course, attorneys French and Sikorsky for helping facilitating amicable resolution between the parties. The court would applaud to you, Mr. Dunn, for reaching your own agreement. The best resolution is one to which you both agree and participate in. So the court will, with pleasure, adopt the agreement. Hopefully that will avoid any problems in the future. Communication is a key. So if one of you are going to be late for a pickup, just as courtesy notify the other party. All right, with that, the court will conclude this matter. Everyone can zoom out. Have a good rest of the day.
Thank you.
Thank you, Your Honor.
You're welcome. You're welcome. For the record, this matter is before the court and the defendant's motion for to show cause. This hearing is being conducted via Zoom. Present is Attorney Timothy Churchill, representing the plaintiff, Martin Brickner. Mr. Brickner, President, Mr. Churchill. In addition, Attorney Anthony Breskel is present, representing the defendant, Jennifer. Brickner, Ms. Brickner is present with Mr. Breskel. Good afternoon, everyone.
Yes, afternoon, Your Honor.
Good afternoon.
I trust everyone had a good Thanksgiving. Mr. Breskel, Mr. Churchill.
Yes, sir. Thank you. Went too quick. Hope you did too.
We did.
Good. Had a better
Well, the
football
parties
game
have
on
conferred with-
Saturday.
The parties have conferred with Ms. Brower this afternoon for the front of the court to provide the court the following recommendation that the mortgage payment on the marital home has been made current. Good. The parties shall cooperate in adding plaintiff on the mortgage note to allow plaintiff to make payments. Defendant will cooperate in assisting plaintiff with access to make the December's payment. The plaintiff's motion for show cause is to be adjourned without date. And finally, the parties will mediate with Joshua Walker from the front of the court on January 6, 2025, 1:30 p.m. And subsequently appear before the court for a pretrial. And if that works with everyone's schedule, the court will vacate the pretrial scheduled for this Friday, December 6th at 1:30. Mr. Churchill, is this recommendation good with your client this afternoon?
Yes, it is, Your Honor.
Okay. Mr. Breskel, is this recommendation good with your client?
Yes, Your Honor. Thank you.
Will discovery have been completed by January 6th?
Pretty much. We've got the appraisal ordered already. We should have that within probably the next 10 days to 2 weeks. So we'll have it in sufficient advance of the January 6th date.
Your Honor, I believe that there's going to be a full and final resolution without a need for too much discovery beyond the appraisal. If it doesn't resolve by then, there may be additional discovery necessary, though, as it relates to some of the personal property. But I think they're going to resolve it without that additional discovery.
Very well. The court appreciates being optimistic, Mr. Breskel. Obviously, there's two good, capable family law practitioners, and they know the value of amicable resolution. So hopefully the parties can reach their own agreement with your assistance. Do the counsel wish to voir dire your respective clients regarding this recommendation?
No.
I don't think it's necessary.
Okay. Fairly. The court notes we took the proofs back in October, so we are all set. The court will vacate the pretrial conference scheduled for this Friday at 1:30 and have the parties appear subsequent to your 1:30 December 6th mediation with Mr. Walker. All right. Thank you both. And thank you, Ms. Brower. That will conclude this matter. Everyone can zoom out. Court will adopt the recommendation.
Thank you, Judge. Thank you, Mr. Churchill.
Thank you.
Okay, thank you, guys. Yep. Thanks, Aaron.
You're welcome.
Okay. Good enough. Have a good one.
Thank you.
Matter of Catherine Vine versus William Vine.
For the record, this matter is before the court for a continued pretrial conference subsequent to the parties engaging in mediation with Joshua Walker from the front of the court. This hearing is being conducted via Zoom. President Attorney Paul Longton representing the plaintiff, Catherine Vine. Ms. Vine appears to be present with Mr. Longton. In addition, Attorney Stephen Rotenberg is present representing the defendant, William Vine. Mr. Vine appears to be present with Mr. Rotenberg. Good afternoon, everyone.
Good afternoon, Your Honor.
Judge can answer.
The court has been informed that the parties have reached their own agreement. Is that correct?
Yes, Your Honor.
Wonderful. Who would like to place agreement on the record?
I can, Your Honor, I believe.
Please,
If Josh is not doing it, I can do it.
Please, Mr. Longton.
All right, Your Honor, it's agreed that the house will be deeded to the plaintiff wife. She'll assume the mortgage, hold the defendant harmless. She'll refinance it to remove his name within 90 days of entry of the judgment. The husband, as a quid pro quo, will be awarded his 401k. Wife will retain her 401k if she has one. There'll be a quadro entered regarding his pension plan. She'll receive 50% of the marital portion with a proportional share of all the usual benefits, including early retirement subsidies, cost of living, etc. If she has a defined benefit plan, he'll receive 50% of the marital portion of that. We're not sure whether or not she has a pension as a school secretary, but we're going to find out. As far as personal property, each person has the personal property they want in their respective possessions, so there's nothing to divide there. The gentleman is awarded his Ram pickup truck. The spouse is awarded her vehicle, which is a 2022 Jeep Compass, which has a loan. She'll assume that and hold him harmless. There are two debts. There's a basement waterproofing loan in the defendant's name, which he's going to continue to assume and pay and hold her harmless. She has a American Express account with approximately $9,000 owed. She'll continue to pay that and hold her harmless. She'll receive the, I'll call it a timeshare, but it's a point system with Hilton Honors. whatever it is, she'll be awarded that because she's paying that debt. And she'll have to pay the annual fee and hold him harmless. So I've covered the two debts that are important, the house to her. I've covered the 2 pensions. He's going to keep his test fee, or whatever it is with Stellantis. He's going to pay, how much a month? Going to pay her $1,100 a month in non-modifiable spousal support, commencing December 1st, 2024, continuing for 5.5 years, again, non-modifiable. There's a temporary order, which Your Honor signed in September, ordering him to pay $2,000 a month to her on the 1st of each month. We understand that based upon what Mr. Walker told us, that he has sent her a check for the $2,000 for November. If that's true, he'll have no arrearage because this new spousal support will commence December 1st. If he did not pay her the $2,000 for November, then he would owe that, and that would be payable forthwith. He's also going to pay to my office tomorrow a sum of $4,000 over the phone by credit card. If he does not pay that tomorrow, then we agree that the spousal support will commence January 1st, 2025, and then he'll owe her $2,000 for the month of December under the temporary order. If I could have just a moment, I want to make sure I'm not leaving anything out. I don't believe there are any other joint debts. If there are any other joint debts, I would like counsel to bring that up when it's his turn to speak. There's no other award of attorney fees, no other obligations on the part of either party. Have I left anything else? That was remind me about something. I believe that's the total agreement, but I'll leave it to Mr. Rottenberg to correct my recitation if it's wrong.
The only one that jumps out.
Hold on just 1 minute. Just a question, Mr. Longton, with respect to spousal support, you indicated $1,100 per month, non-modifiable in terms of amount or duration. Is that correct?
Correct. For 5.5 years.
The duration
non-modifiable as to amount and duration for 5.5 years.
We thought we pay this. If it came up, we could do a lump sum because it's a fixed amount. So if, let's say, 2 years from now, he decides to pay off whatever's left, I don't really think that we should have an objection to that.
No, of course not. Of course not.
Right. Okay. All right. The other thing too is I'd like to give a clarification because I believe she has a 403B, possibly not a 401k, because she works for a government entity.
Correct.
And I have just said one other thing. My client just scribbling something down, so I need to figure out what he's.
But part of the agreement was she would keep her 403B. He's going to keep his 401k.
Right. Right. Yeah, I was doing it for clarification, not or correction, not to make additional claims. What do you want?
Can the spousal support be set to be paid on the middle of the month?
Can we set the spousal support to be paid around the 15th of the month?
Well, we typically want to do it by an order of income withholding, and what they'll do is if he's paid twice a month, then they'll take it out twice a month. So he'll have what he wants.
All right.
Okay.
That'll work. The only issue then being if we do an income withholding order, there might be a little bit of a delay in the system.
Of course.
So I don't want him to be penalized for that or show cause for that.
She'll have to be patient.
Thank you.
So Mr. Roberg, other than those clarifications, did Mr. Longton accurately state your client's agreement?
Yes, I believe so.
Yes,
and with respect to spousal support payments, Mr. Vine should look to see what's coming out of his paycheck. If it's not coming out of his paycheck, he should pay that directly by check, or let's have some documentation to verify that payment. He shouldn't wait the 2 or 3 months before that takes effect.
Right. My client wants to ask a question. Just a sec, Judge.
Judge, does it have to be done that way, or can I pay her monthly? And if she doesn't receive it, then if she wanted to show cause me, I can do that too. But that way I know it can be done through certified.
You can do electronic transfer into her bank account the 15th of every month if the parties agree upon that. You can then always she can opt into the friendly court if she's having trouble, and we can do it by income withholding order. So yes, you can pay it directly if the 2 of you agree.
It's up to her. I would agree to that, but it's up to
Your Honor, she would prefer to have the order of income withholding because he's not been timely in paying under the temporary order.
Okay.
Judge, he paid the first one thing 4 days after you ordered it to him. He's paying it as quickly as he can. So I wouldn't say he's not been timely.
Okay, but if the plaintiff requests that be through the front of the court, so be it. That's what it'll be.
Okay.
I'm good with it.
And it might be easier for Mr. Vine to he can make 2 payments per month rather than 1 lump sum. But until it comes out of your paycheck, Mr. Vine, you should pay that directly to Ms. Vine so you don't have a significant arrearage. Wonderful. All right, Mr. and Mrs. Vine, can you both please raise your right hand to be sworn, please?
I do.
Thank you. Mr. Longton, we took the proofs back on October 15th. So you can just verify with Ms. Vine that she's currently not now pregnant. Then you confirm with her in terms of this agreement, please.
Sure. Ma'am, are you currently pregnant?
No, I'm not.
Okay. All right. She's smiling, Your Honor.
Thank you.
You understand that by agreeing to the non-modifiable spousal support, you're actually waiving your right under Michigan law to have the court consider modifiable spousal support with no end date. You understand that you're waiving your right to that.
Correct.
Understand that your waiver is final and binding.
Correct.
And then if you become ill tomorrow or get in an accident, you can't come back and ask for a redo. You understand that?
Correct.
You understand that the $4,000 that your husband is paying to my office tomorrow will be credited to your attorney fee account. And if there is any credit balance, that'll be refunded to you.
Yes, I do.
And you agree to that?
Yes.
Now, do you consider the property settlement fair and reasonable?
Yes.
You understand you have an obligation to refi that house within 90 days?
Yes.
And to remove him from liability?
Yes.
Your Honor?
Thank you, Mr. Longton. Do the parties want to get divorced in 2024 or will it be submitted after January 1st?
I think she wants to be divorced in 24, Your Honor.
Okay,
Let's
all right,
do it.
and you'll prepare the judgment, Mr. Longton?
What about tax? How do
Prepare the judgment, Mr. Longton?
need to worry about it?
I'll prepare a judgment, Your Honor.
Thank you. Mr. Rosenberg, do you have any questions? First of all, from Miss Catherine Vine.
Ms. Vine, is this an agreement that you reached on your own with your attorney?
That is correct.
And nobody made you any promises or threats or anything like that to reach this?
No.
And you realize that you could have gotten a different result, better or worse, or possibly the same had you gone to trial?
Yes.
And you realize that by having the settlement agreement, you give up the right to confront witnesses, call witnesses, or basically have a trial.
Yeah.
Okay. Are you
Mr.
happy?
Rosenberg, questions for-
Are you happy with your lawyer's representations?
Yes.
No further questions of Ms. Vine?
All right, Mr. Rosenberg, questions for Mr. Vine, please.
Yes. Okay, Mr. Vine, is this an accurate recitation of the settlement?
Yes, it is.
And did you reach it on your own without you decided this yourself, right?
100%.
And nobody made you any promises or threats or arm twisted you in any way to get here?
No, sir.
You realize that by reaching the settlement, you give up the right to a trial.
I do.
And you realize you give up the right to confront witnesses or subpoena evidence, etc.
I do.
Are you satisfied with my representation?
I am.
Do you have any other questions for the court?
I do not.
Okay.
Thank you, Mr.
I
Thank you,
guess
Mr.
maybe I
Rosenberg.
do. I guess maybe I do have one quick question. So the divorce will be final in 2024, but for income tax purposes for 2024, what typically or normally is done on this? Are we
Be married filed separately?
okay? I'm good.
Because marital status as of December 31st. So if you're divorced and before December 31st, you file separate, not married, but
Okay.
separate.
Okay.
Single and separate. If you,
I just have one question for Mr. Vine.
Yes, sir.
go ahead, Mr. Longton.
Sir, our office closes at 4 p.m. each day, so when you call the office tomorrow, you have to do it before 4 p.m.
Hey, Mr. Longton. So I'm okay to call the office in the morning and then I can give you the numbers that you guys need.
And
Yes, sir. That's excellent. Thank you.
for the record, my client has my permission to contact Mr. Longton's office directly
Thank you.
and discuss this.
Right, thank you. So Mr. Longton, you'll prepare the judgment. You'll get that to Mr. Rosenberg for his review and approval and that of his client. If he submit it before the end of the year, the court will sign it. So that's the intent, Mr. and Mrs. Vine, is for the court to receive that judgment, sign it yet this year. So you're divorced before the end of the year.
Your Honor, we will submit it to Mr. Rottenberg no later than Friday for his review and correction.
Thank you. Very well, the court would like to thank and acknowledge Mr. Walker for his assistance in helping facilitate a resolution, as well as, of course, attorneys Rosenberg and Longton. And the court would applaud you, Mr. Vine, for reaching your own agreement. Without question, the best resolution is one in which you both participate, as you have this afternoon, reach your own agreement. Far better off than a trial before this court. Based, however, on the testimony that's been presented today, as well as previously, and as well as complaint filed in this case, court finds again that jurisdiction has been established. There's been a breakdown of the marriage. There's no chance of reconciliation. Accordingly, upon receipt of the consent judgment approved by the parties, the court will sign that judgment. And at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from the bonds of matrimony. Good luck to both of you. I guess one last question, Mr. Longton. Does Miss Vine want a former name restored, or maybe I missed that?
He does, Your Honor. It's Dykow. She wants her former name restored. Thank you for asking.
Okay.
Yes,
All right.
thank you, Judge. I appreciate you asking that. I'd forgotten all about that.
Okay. All right. That'll conclude this matter. Thank you again, Mr. Longton and Mr. Rosenberg, and good luck, Mr. and Mrs. Vine. You can zoom
Thank
out. Have a good rest of the afternoon.
Thank you.
Thank you.